Good morning and welcome to the 14th meeting of the Rural Affairs and Islands Committee in 2025. Before we begin, can I remind everyone to switch their electronic devices to silent. This morning we have apologies from Evelyn Tweed and I'd also like to welcome Mark Ruskell. Beg your pardon, Mark Ruskell. Goodness, I've known you for long enough, Mark. Beg your pardon. Who's going to be joining us as our newest member. And I'd like to take this opportunity to thank Ariane Burgess for her contribution to the committee's work since the beginning of the parliamentary session. We'll also be joined at some stage this morning by Edward Mountain. We turn to our first item on the agenda, which is consideration of the Natural Environment Scotland Bill at Stage 1. At today's meeting, our focus will be on Part 4 of the bill relating to deer management. First, we'll hear from representatives from Nature Scot, and then we'll host a roundtable discussion with 9 stakeholders with an interest in deer management in Scotland. But before we begin, we've been joined with Edward Mountain. Edward, would you like to make any declarations of interest?
Thank you, Convener, and I'm sorry I was slightly late to the meeting. My watch obviously isn't as accurate as yours. I would like just to declare that I've been involved in deer management for over 25 years. I've written deer management plans for various subgroups, including ones in the Cairngorms and ones further north, some of which are still in place. I am involved in deer management at home on the farm, and I've taken a great deal of interest in it. Not all of that is in my register of interest, but as a landowner, I'm sure your committee members will understand that deer need to be controlled, and they are controlled at home. Thank you, Convener.
Thank you, Mr Mountain. So for the first session, I'd like to welcome to the meeting Donald Fraser, who's the Head of Wildlife Management, and Robbie Kernahan, who's the Director of Green Economy at Nature Scot. We have approximately 60 minutes for this session, and just before we move on, just to make you aware that you don't need to operate your own mics. We've got a gentleman that will do it for you. So I'll kick off with the first question. Section 10 of the bill amends Part 1 of the 1996 Act, which covers Nature Scot's deer functions. Now, the bill updates the aims and purposes of deer management to include the public interest. Additionally, the environment is now something Nature Scot should take account of when carrying out its function. So can I ask, will this change what Nature Scot is already doing on the ground, and how will that affect resources and capacity within Nature Scot?
I'm happy to start, Convener, and thank you. Pleasure to be here. I think in response to the question, this bill really is an opportunity to modernise the deer management legislation, which, when it was first enacted in '59, hasn't really changed significantly. And it's a good opportunity to continue to bring this piece of legislation, I suppose, up to the level we would hope for when we're thinking about nature and climate crisis in Scotland. So the reference to our functions in Part 1 and inclusion of the environment and updating our aims feel to us absolutely the right thing to do. And in defining the public interest, we've always had to take that into account. But you appreciate with the importance of nature and climate now, both in policy terms and the pressures coming to bear through the land use lens, it feels the right time to make sure that the deer legislation, and taking a step back, deer have and will continue to shape our environment for many years to come. It's important that we use the best possible evidence and that references to current challenges are reflected in the legislation.
Thank you. So, do you think it's going to make any effect on the capacity for Nature Scot with the new powers that it will have and having to enforce those?
In terms of Part 1, I don't think this makes a significant difference to how we will administer the legislation. And again, taking a couple of steps back, all the deer management system in Scotland is predominantly based on the voluntary system. And this Act provides a mechanism or a range of mechanisms where we might intervene to deliver the public interest. And I think in defining the public interest, we do need to take into account current policy changes and current challenges, but I don't think it will make a significant or material difference to the resources that we currently put into delivering it.
So the public interest is currently undefined. What do you see as the public interest?
Do Do you want to first go, Donald?
Yeah, I mean, so there's a whole range in there of public interest, and the 1996 Act kind of set out some of that in a bit of detail, and the natural heritage was referenced to the 1996 Act, but natural heritage is quite a specific term. The environmental aspect of it and the wider biodiversity climate focus that we find ourselves in now obviously broadens out that public interest to a range of areas. And while it's not, you know, and it was explained, I think, at the last committee meeting, that there's a kind of understanding of the public interests that are out there and being delivered on a series of land management spheres. Deer management is obviously part of that, and there's a better understanding of that now.
Can you explain why that definition of public interest is not in the face of the bill? Because there is some attempt to define it in part of the explanatory notes, but it's not likely to change in any great detail. So why is that not on the face of the bill?
I think there are aspects of the public interest which are more clearly defined, Convener, in the fact when you think about the needs of agriculture and forestry, which were the original basis on which deer legislation was introduced to try and protect those interests which were in the public interest at the time. The 1996 Act for the first time introduced the concept of natural heritage, quite clearly in the public interest. And then more recent changes beginning to explore wider socio-economic and environmental objectives, which are sometimes quite hard to express on the face of primary legislation. But to give some examples, they might include things like water quality, carbon sequestration, some of the emerging drivers for ensuring that we deal with flood management, with carbon management, which probably are not easy to express in primary legislation, but are really important that they're referenced, and we can then begin to work with the sectors and others to put some colour and substance behind that, which, of course, the Code of Practice for Deer Management provides a mechanism to help articulate that more robustly.
Given we're going to see things like the climate change plan, biodiversity plans, we've got the Rural Communities Act now that will have different objectives. Those, the public interest might change. Do you think there's a role in secondary legislation for this Parliament to look at the explanatory notes in terms of the public interest, to make sure that the Parliament has oversight of what the public interest might mean and the impact on land managers?
Well, I think you've just expressed very clearly that public interests do change over time. And whilst we've got some references on the face of this bill recognising that, I actually think the solution is to be able to pin down those more explicitly in probably secondary legislation and other areas of guidance where there's consensus that things have moved on. I think that's probably as much as I can say in response to that. Convener Donald, I don't know if you want to add.
Well, I think the point here is to be clear about where the mechanisms in the Act, and particularly the regulatory mechanism in the Act, can and will be using that, so that there's a clarity there for the stakeholders, those who are involved in managing deer. So that is important. The mechanism for that, whether that's through primary legislation, secondary legislation, or through development of the deer code in itself, potentially provides a mechanism for that. So there is that clarity there. But that is important to have. Yeah.
So I'm getting from that there may need to be something in secondary legislation that clearly defines what might be within that public interest, given the changing scene of other pieces of legislation, to make sure that stakeholders know what's coming down the road, if you like, whether it's proportionate and actually addresses what this bill is supposed to achieve.
I think whether it's in secondary legislation, Convener, or whether it's actually defined in the code, I think we're quite relaxed about. But it is important for all those people involved in deer management that we can clearly define those circumstances where we will intervene in the public interest, that's collectively understood, clearly defined and articulated and well evidenced.
I suppose what I'm trying to get at is the Code of Practice is obviously going to play a critical role in this. It's almost like a framework bill, and the Code of Practice then puts the meat on the bones. So should that Code of Practice undergo more scrutiny from the Parliament and not just be left to Nature Scott to pull together, whether that's co-design or whatever? Does there need to be an oversight from the Parliament of the Code of Practice?
Well, I think, again, we're quite relaxed about that, and the fact that there are some proposed changes to the frequency within which we review the code. and it sets out the process for how that would operate in practice. Again, I think the most important thing from our perspective as a regulator is to make sure that the sector are cited and involved in development of the code, that's clearly understood and articulated, because that actually provides quite a significant basis on which we will intervene.
Tim Eagle.
Thank you. Good morning. Really interesting discussion there, because I think that's part of the problem with these framework bills, isn't it, is that these aren't defined. So actually the stakeholders don't really know what's going on. So can I ask a few questions around the Code of Practice? Because this actually, I think, will be instrumental in helping everyone to understand what this bill will actually do. I'll start with Section 12 of the bill, changes when Nature Stock can review compliance with and effectiveness of the Code of Practice. How will you decide when it is an appropriate time to carry out a review of that?
So I think the easiest answer to that, Tim, is that we will inevitably need to take out a review very, very quickly in terms of being able to reflect the range of circumstances by which Nature Scot would intervene as set out within these provisions. Again, traditionally it's been quite straightforward for us to be able to articulate the things that you must do within the code because it's a legal requirement, the things that you should do within the code because if you don't, it exposes you to the risk of regulation and intervention. And those are currently articulated based on the existing provisions. And also those things that you could do because we consider it to be best practice. That is a tried and tested formula which I think the industry understand and we are quite comfortable provides, I suppose, a range of options whereby we might ratchet up our intervention. And it's the second point I think is the most important aspect of that, to help develop and articulate and put the colour and substance on those types of situations where Nature Scot may actually look to introduce Section 6, 7, 8 and 10, the regulated aspects of the bill. And again, I think the simplest way to do that in the code is to use examples and a range of circumstances whereby actually, if we take the view that voluntary mechanisms are not currently delivering on the public interest as clearly defined in a geography, that could be, I don't know, river basin management planning, riparian restoration. It could be peatland restoration. There could be a range of different circumstances, all of which probably constitute aspects of the public interest. We would want to be able to articulate those and express those in a range of circumstances. Donald, do you want to add to that?
I think just in terms of the review, so in terms of the current legislation, the review we're looking at on a three-yearly period, which is quite prescriptive in that, it's quite a short timescale actually in terms of some of the changes that we're looking at. So the change within the bill as presented is to provide a little bit more flexibility around that and a time for bedding in of some of that changes that are taking place in the code, because the code will have to go through a fairly fundamental review to look at the new provisions that come through in the bill. That provides that time to do that and to have that review, but it allows it a bit of flexibility there in doing that so that we're not constantly reviewing. There is obviously a need for the checks and balances there to make sure that the code is fit for purpose in that time frame, but it provides that flexibility in terms of the prescriptive nature of that.
I think if I may just follow up as well, obviously if there are aspects or if there are parts of the sector that are not comfortable with the clarity provided in the code, that in itself might provide a mechanism or a trigger for us to say, OK, well, we need to be able to express that more clearly because there is a lack of understanding. But hopefully we would avoid those circumstances, Tim, by ensuring that there was co-production of the code from the outset of each time we reviewed it.
And can I ask, what's Nature Scot's relationship with the code? And I ask that because my understanding is in the 96 Act, you had to have regard to the Code of Practice. Now, there's some, I think I'm not quite clear now, because in some parts I think that have regard to has gone, but I think in Section 5 it remains. But actually, that's not particularly strong, is it? So actually, that's a finding you kind of have to have regard to it, but it doesn't really matter. But in your mind, will Nature Scot clearly work to the code that is produced? So,
again, taking a couple of steps back, the code is still relatively new in terms of it wasn't developed in the 1996 Act. It was developed later on, and it's an attempt again to provide clarity and guide behaviours for those deer managers that would need to take into account of it. Whilst we do as well, it was very much driven by trying to direct behaviours of deer management practitioners about what they can, should and must do, And in exercising our functions, we would obviously want to take that into account. That, in principle, will still apply, regardless of how it's prescribed in primary legislation, because we want to use that code as a means by which we can clearly set out the circumstances where we would be applying regulation.
But, I mean, I looked it up. So I've got here, case law from 2014 notes that to have regard to a matter means simply that that matter must be specifically considered, not that it must be given greater weight than other matters. So I guess when some of the stakeholders are coming to me and saying, I don't know what Nature Scott are really going to do with this code of practice. You know, so I think they need that explicit knowledge that everything you write in here will be built with them as well, but actually that will be what you follow as well.
So I think the code is obviously setting out the intervention that we have from a regulatory perspective, and of course we have regulatory duties in terms of discharging our functions, and having regard to the code within the legislation is one part of that. But in being clear about how we implement our regulatory functions, the code is a key part for us in terms of discharging that and making sure that we are setting that out and being, following the principles of better regulation there in setting out when we will act and how we will act and what basis we will act. That code is key to that.
One more very quick question, if I can. Do you think then it would be better in the primary legislation to have regard to comply with, because that might give certainty to stakeholders? And also, I guess, the big thing, and Finlay Carson, the convener, picked up on this, do you think actually it would have been better if actually the code had come along with the sort of bill? Because actually the framework nature of the bill means we don't really know what we're talking about here. Do you think there could have been a draft that could have been produced along with the bill?
So again, I think taking a couple of steps back, the primary purpose of the Code of Practice of Deer Management is aimed at deer practitioners. It's for them, it's to help them understand how they can deliver sustainable deer management in Scotland. And as I said, it's structured in a way which is trying to ensure that they understand the legal requirements, the things that they could do to avoid the prospect of regulation, and the things they should do because could do because it's best practice. That's reasonably well understood under the current provisions, and I think where there is a need to look again afresh at it are based on the new provisions where there are interventions under 6ZB about enhancement and restoration, because that's new, Tim, and that does require some time to work through that and to provide hopefully reassurance to everybody that that's well articulated and well understood.
Just before we move away from the code, now, we know that the Code of Practice has got to be approved by Parliament, but the work on pulling that code together in terms of working with stakeholders has not yet begun. Would it not be desirable for a draft of that Code of Practice to be available prior to stage 3 of these proceedings, just so we know what it's likely to look like, but it also then allows stakeholders to know what's coming down the road? Because we've seen other situations where framework bills have required a Code of Practice, and it's been quite some time before that Code of Practice has actually been approved, and it sometimes has been quite difficult. Looking at hunting with dogs, some of the Wildlife Muirburn Bill, Code of Practice, even definitions within the Agriculture Bill. So would it not be sensible for that work on producing that Code of Practice to start now, and for the Parliament to be able to see what that's going to look like in draft form prior to the bill going through?
I think in response, Convener, there is a slight difference in this specific circumstances compared to Sustainable Agriculture Code or other codes of practice, because we already have a Code of Deer Management, which is well articulated and understood. And whilst we're happy to reflect on that, I don't suspect there will be a significant change to the structure of how the Code of Deer Management actually works in practice. It's much more about updating it and refining it and doing that to help articulate these new provisions and how they're expressed. So whilst I don't think we're opposed in principle to continue to start that conversation, I think actually it may well be limited by capacity.
Okay, so it's not something that you're considering starting work on, so we can give some reassurance to the stakeholders and land managers at the moment, no?
We can start those informal discussions. Indeed, we already are, but it's not with the express intention to progress the two things in parallel, Convener. But happy to reflect on that as the bill progresses through each stage.
Was it there was not a precedent set with the Wildlife Muirburn bill? Was there not? The code of practice it started being built up prior to that piece of legislation being concluded. So it's not unusual.
No, I mean, we can start that process. The code was not developed in advance of the legislation, the bill going through and becoming an act. The process had started in that. So there was, so there was stakeholder engagement in that process, but there was no finality to that by the time the bill had progressed.
Okay, thank you. A question from Rhoda Grant.
Thank you, Convener. Section 13 adds nature restoration as a reason for intervention in deer management, but control schemes under Section 8 powers of the 1996 Act have not been used until quite recently. So I wonder if the new powers in the bill change your approach to intervention, and should we include in the bill things that you must intervene on?
Okay, so again, I think it's just useful to remind ourselves that this bill and some of the provisions are trying to ensure that NatureScot, as the regulator, is able to intervene proactively to begin to try and preempt problems before they arise. And one of the potential limitations of the existing legislation is the reactive. It's responding to concerns about damage and trying to prevent damage. It doesn't allow us to get on the front foot and start thinking about deer management planning in areas where we would like to see enhancement and restoration. Indeed, some of the provisions historically have prevented us from doing that. So this is an attempt to make sure that we are equipped, forward-looking, and able to put in place deer management provisions to enhance nature rather than to respond to concerns about damage. So from our perspective, that's a very positive change. How that plays out in practice, I suspect, will introduce a degree of complexity whereby we have got an area of land, a control area, and there is, I don't know, maybe mixed appetite to be able to respond to some of the deer management provisions which are expressed, and I suspect will lead to maybe more common interventions where Section 8 is more readily used, because it is an exception at the moment. We haven't used it in very many circumstances. Indeed, it's only recently passed that ministers have signed off Section 8 control schemes for the first time in Scotland. And some of that is symptomatic of the fact that it requires quite clear deterioration from a baseline, and some of the habitats that we've been looking at have already been at reasonably low environmental quality. And indeed, I think as a result, if we are serious about realising our aims for restoring and enhancing nature by 2030 and 2045, Section 8 perhaps could become more commonplace.
I think just to come in on that as well, I think Section 8 is almost the end of a process, and that there's been a failure in that process to get to that point, because that's in at one end of the regulatory piece. Whereas, as I said earlier, voluntary approach, ratcheting up into looking for management plans to be in place, looking for voluntary control agreements to be in place, then you get into the control scheme area. So it's about Section 8 is at one end of that, but the whole process is to make sure that the enhancement and restoration piece is seen in the context, in a similar context to the damage piece that we've got just now, in that it's changing that focus and efforts around deer management to make sure that there is those abilities there, to make sure that we can have those proactive discussions around some of those areas to make sure that we're getting that enhancement and restoration that's required.
So the new powers would be used earlier, is that what you're saying? Or is it at the same period, but your intervention wouldn't be so dependent on gathering information about kind of degradation of the area? It would be to actually take it from the current base and increase it rather than bring it back to a state it had once been.
There's a number of provisions within the bill which kind of streamlines to an extent the process in terms of moving through the Section 6, 7, 8 process to make sure there aren't unnecessary barriers there. There are appropriate checks and balances in the process there to make sure that we are, as a regulator, responsible for that. But there is some streamlining of that in a sense. But yes, the evidence base around some of that is clearer, or can be clearer in some of that, particularly if that's set out in clear terms within the code that we talked about earlier.
So can you give us some examples of where you would now intervene, where you would intervene under the bill rather than what would have happened previously? And also let us know whether we should be putting in the bill circumstances where you must intervene.
So, I mean, again, I think taking a step back and looking backwards, we have exercised powers under Section 6 and under Section 7 over the last 20 years, predominantly on areas of designated sites where nature objectives are quite clearly expressed. And whilst deer management arrangements have not been restricted just to those areas, because, as you know, we have to look at what would constitute a sensible control area, that's been the trigger for intervention. Increasingly, when we think about public interest maybe being expressed in carbon terms or water catchment terms or water quality, we might be looking at catchments that are not designated for natural heritage specifically, but there is quite clearly a need to make sure herbivore pressures are not preventing establishment of woodlands or restoration of peatlands where the drivers may not be designated sites. And I think looking at those catchments is probably relatively new for us, but quite clearly, based on the way these provisions are written, we would be expressing our desire for deer management planning to be much more effective in some of those areas. And of course, as Donald's articulated, that could begin to change the nature of our relationships, where it's a much more formal, we would like to see a deer management plan in this area being applied. And ideally, you know, the owners come together, facilitate a deer management plan which largely satisfies any concerns about whether or not herbivore pressures are going to prevent establishment or restoration of habitats. And if we need additional assurance, then we might look to underpin that with a Section 7 control agreement, which again is voluntary, but provides a degree of formality and a relationship between NatureScot as the regulator and the owner-occupiers of that land, that we've got the process in place to check on an annual basis that progress is being made. And where we haven't been able to secure agreement, either on an individual or collective basis, we would find ourselves in circumstances where a control scheme might be applicable, where there is less room for negotiation, but we remain quite clear in the view of the deer management measures necessary, either to prevent damage or indeed to restore and enhance the habitats in question. Does that help explain how it might work in practice?
Yes, but it doesn't answer my final question, which was about should we be putting in the bill examples of when you need to act. So I suppose, for example, if one landowner complains that their efforts at nature restoration are being hampered by another landowner, would you then react maybe on wild salmon? You know, if you felt that rivers were not being maintained properly, should we be putting in the bill that you would need to act in those circumstances?
So on the specific provisions of when we might interact, I mean, some of those circumstances are articulated more clearly than others, and I think most of the concern is actually about the new provisions about responding to the need to restore and enhance nature, because that could take a variety of forms. Comes back to how we articulate and express that. Our expectation is that that will be much more clearly articulated in the code of practice rather than the face of primary legislation.
Tim Eagle, then Emma Roddick.
I've got to clip my little flock of sheep soon, and a bit like that, this all seems just a little bit woolly for me. So I think it's just clarity, isn't it? It's understanding. So you mentioned earlier on, I think, about case studies in the Code of Practice. So are you giving that guarantee? Because actually, what does restoration mean for one holding, the holding next to it, etc., etc.? So you will put not just case studies, but clear guidance within the Code of Practice and work with the sector to make sure we know what that means.
Yeah, I mean, I think it's the clarity there about making sure that public interest that we're delivering has a high-level strategic nature to it, in terms of that's been signed off by Minister's Government, in terms of policies that is doing at a national scale, at a regional scale and looking at that in the locality, so that there is a clear line of sight there almost in terms of where that public interest has been derived from and what we're trying to achieve there. I think I'm going back a little bit to the question over there just about making sure that how prescriptive can we be in that is slightly difficult in that deer management is usually, and it's quite often, a significant factor in the delivery of the environmental benefits that we're looking at. But it might not be the only factor in that too, that we've got to look at, invasive non-natives or other aspects of that. So we have to look at that and around a bit more of a holistic approach to what we're trying to achieve in these areas and how we're doing it. But where there is that deer management need, then that's clearly articulated and set out. And the code, we've talked about the code doing that in terms of setting that out from a very strategic nature right down to looking at how that would be applied in practice.
Okay. I mean, I should have said, I think criteria is also very important within that code, isn't it? Are you aware of the financial memorandum and how it lays out how many times you expect to use these new powers under nature restoration?
Yes, we contribute to the financial memorandum.
How did you come to that out of interest? Like, what made you, because I mean, I've got it written down, 3 to 5 deer management plan, 9 voluntary control agreements, 1 to 2 control schemes. How did you come to those figures?
So they're based in historic look at how we've tried to apply our current regulatory powers in terms of damage. And we're looking at that in terms of, well, what are we resourced to do it to an extent, in terms of looking at in line with the Scottish Biodiversity Strategy, which is one of the drivers of looking at what we're trying to achieve here, and trying to make sure that we've got a programme of work, essentially, that fits with the resources that might be available to us. And the scale that we're trying to influence and change for 2030 and 2045 targets. So we've looked at that on the basis of, well, what's the work programme almost that we can look to deliver on that. Now, whether we get to Section 8, in terms of, it's all dependent on the nature of that case-by-case work that we're doing and how much engagement and how proactive people are in doing that. But as an example, we've put out there that those are the levels, the kind of maximum levels that we'd be looking at to in terms of resource that's available. And
just finally, very quickly, do you then already have, I mean, to come to those sort of figures, I presume you've already had some quite detailed work in the background. So, I mean, is that something you can release then? Like, if you've got a set of criteria, draft criterias or draft something that could be released so that we have an understanding of how you're coming to these figures in the financial memorandum?
Yeah, I mean, we've based the figures on information that we've looked at. Slightly hypothetical in terms of the areas that we might be focusing on, but in broad terms, looking at the costs in terms of how we implement and do our current regulation. But we can provide some information.
Okay.
So, in that case, it's not important that criteria is actually on the face of the bill, or far more clearly set out. If you're able to estimate and put together something in the financial memorandum, it must be fairly robust. If that was available to stakeholders, that would make it far clearer what limitations they're working within.
I think in response to that point and Tim's point, it's actually we can't regulate the system everywhere. That's not the way the system works in Scotland. It's a voluntary system of deer management, and we are only really looking to intervene in those cases where the voluntary system begins to break down. We've got experience of that over, Donald and I, 25 years of implementing deer legislation in Scotland, and based on existing criteria set out in those existing provisions. But having a forward look about what the Scottish Biodiversity Strategy is expecting in terms of deer management, about understanding the need for landscape scale restorations in certain parts of the country, about understanding SEPA's desire for more effective river basin management planning. We do expect...
So you talk about landscape scale. How's that going to work on a voluntary basis when you might get some people opting in and opting out? Will that increase the number of times you're going to have to statutory enforce deer numbers rather than voluntary? And has that been taken into consideration?
Well, that's kind of how it works already, Convener, in the fact that we've got a number of Section 7 control agreements over fairly significant areas of land where we might have 12, 13, 14 estates all signed up to voluntary control agreements. And in terms of how we regulate that, it's negotiated and it's negotiable. And actually, that's still our preference, to work within the voluntary system. It's only when the voluntary system breaks down, which still tends to be the exception, that we might be looking to use Section 8 as a means to deliver some of the restoration as expressed, and perhaps spatially explicit through other plans and strategies. And I think that's the difficulty of putting that prescription on the face of the bill, because the Scottish Forest Strategy or other things will have targets in themselves, and some of that will be spatially expressed, and it's difficult to translate that into primary legislation for deer.
Okay. Emma Roddick.
Thank you, Convener. I just wanted to pick up on Rhoda Grant's line of questioning there, because I think there were some interesting points raised around where there should be a duty to intervene or a trigger for your intervention, and I'm not clear the position on whether that should be the case. But I think this is going to be an area that the committee is going to have to look into in detail, so it would be good just to hear a little bit more about your position on that.
So again, taking a step back, fundamentally the responsibilities for delivering sustainable deer management rest with owner-occupiers. Those people that have got the rights to take deer have got, with a certain amount of responsibility to ensure effective deer management is taking place. That's what the Code of Practice continues to set out in a variety of levels. I suppose the question is about at what point within this legislation puts additional duties on Nature Scot to regulate the system under certain circumstances. I'm not entirely sure what more I can offer other than look at what's been drafted here, which sets out the types of circumstances where Nature Scot may regulate rather than will or should. But again, I hate to come back to it. We would hope to be able to express that more clearly within the Code of Practice. But again, maybe that's something the committee wants to take some further evidence on. Donald, I don't know if you want to add to that.
No, I mean, the underlying point here is about the change of kind of approach and behaviour towards delivering for biodiversity and climate principally, but the measures around deer management for making sure that we've got enhancement and restoration. But being prescriptive about, adding Nature Scot must act in these circumstances may not, it potentially opens that up to being undeliverable in terms of having to act in too many circumstances where we're not resourced to do that. But what we're looking to do through the code and setting that out is saying that, look, there's a prioritisation process here where we're going to, because we can't do everything everywhere. The scale of deer management issues throughout Scotland, are vast and significant, but we need to have a kind of planned and prioritised approach to that. And I think it's the structure around that that's important to make sure that there is clarity with stakeholders about where and when we will intervene. But as much information as possible in terms of how we see that as being a prioritised approach, aligning with other government or the significant government or public interest policies that are out there.
As my brain's catching up with the questions here, I do think again there's a fundamental question here about the voluntary system in Scotland. It is a voluntary system, and we only intervene where that voluntary system is failing. But we can't apply regulation everywhere. So I do think that's why we need to be quite judicious about interpreting where and when we're going to intervene, because we are limited by the resources that we have to regulate a voluntary system.
So if there would be a resourcing issue if there were a duty to intervene, does it not follow that there's a resourcing issue with when you feel you should intervene?
So again, I think we have a degree of discretion where there are circumstances where Nature Scot should intervene rather than where we must. And if the face of this bill suggests that we would have to intervene in certain circumstances, that's a significant shift, I would have thought, in terms of how we would resource the system.
Okay, thank you. Mark Ruskell.
Yeah, I'm pursuing that kind of line of questioning. I'm really interested in the reasons why that Section 8 power has been used so infrequently over the decades. It feels like it's almost been a redundant power. It is part of the reason there that there's an inbuilt fear of judicial review within Nature Scot and SNH. To go back to Emma Roddick's point around resourcing, if you're going to use that option of a Section 8 power, someone's going to challenge it, and you need deep pockets.
I think fundamentally the answer to that question is no, Mark. There's no fear of judicial review within Nature Scot. The legislation as drafted has a process which allows appeal and challenge, and more than happy to continue to test that, because only by doing that will we understand and learn whether the prescription is right and whether our approach has been right. I think some of the concerns about Section 8 is about we have always needed to be clear about expressing damage, and sometimes that's been quite a difficult thing to do on the face of robust scrutiny about how that's evidenced. As I mentioned earlier, about where actually the starting point for quite a lot of these schemes is a relatively low baseline in terms of condition. Very difficult to show deterioration from condition where actually it's not in great shape to start with. And I think,
I mean, thinking back to examples of that over the years, would you say that was the case with the Ardvar estate a number of years ago, where there was real questions as to why Nature Scot at the time was not using Section 8 powers to intervene? Is it because it was so deteriorated it was difficult to prove? Or?
Well, again, just to be fair, there probably was a case for intervention in Ardvar, and we were certainly satisfied actually we'd failed to reach agreement. But obviously, Section 8 control schemes are signed off by ministers and requires ministerial appetite to regulate the system.
Okay, so would you expect as a result of this bill there to be potentially more or less risk of judicial review? Or do you think there's enough certainty within the bill, and there'll be enough certainty coming out of the Code of Practice, everybody will know where they stand on this, and it'll be quite clear that a Section 8 order is a Section 8 order? And
that's certainly our aspiration, Mark, and the bill and the changes that it's making is putting the deregulation on a modern front foot, clearly articulated, intervention powers clearly expressed, reinforced and understood through the Code of Practice, and the mechanisms by which Section 8 would actually work and be challenged are modern and fit for purpose. Because having just gone through the process, there are inevitably still hiccups within the existing system which we'd like to see changed, and this bill provides the mechanisms to do that.
Yeah. Just to come in the judicial review point, I mean, judicial review is around the challenge to Nature Scot's processes in delivering through on the regulation and the delivery of the legislation. So, as long as our processes are in place, then that risk of judicial review is reduced or lessened or negated in that respect. Some of the challenge that we have is making sure that the kind of test and the point that we've got to satisfy ourselves of in the legislation is where some of the challenge would come from our perspective, making sure that we're satisfied in that. The actual process of delivering that is down to us making sure that our processes are in place and not challengeable.
Okay, so I mean, just to go back to the example then of this month of a Section 8 order actually being issued, I think you said in your comms that you can't be satisfied that effective deer management will be put in place to address risk of significant impact on peatlands, woodlands and other habitats. What does the new Section 6.7b then add to that? Because 6.7b is about restoration. Does that really change the nature of your consideration of the Section 8 powers? Because it seems like you're already acting on an example of where there's deterioration, but also an urgent need for restoration. So I'm struggling to understand how 6.7b really adds anything significantly to that, but maybe you can explain.
Well, maybe have a first cut and then let Donald follow up. So circumstances in East Sutherland is that we have got a range of designated sites that are negatively impacted by deer and are suffering damage as a result. There was consensus amongst the local deer management group that needed addressed in the deer management plan, and we've got an individual estate who's not part of that and not willing to sign up to a local deer management plan, and we were unable to secure voluntary agreement on that basis, hence the need to ratchet up the regular intervention and use a control scheme to ensure that deer management provisions were in place to address concerns of damage on designated sites and designated features. I suppose the difference in terms of 6.8b is circumstances where it's less about dealing with damage and much more where there is an express desire to restore and enhance over and above concerns about damage. And I think that's quite an important distinction to make, because we've never really had the opportunity to think about where we would like to see intervention to restore and enhance nature, to deliver for nature and climate outcomes in a way which is more about those positive outcomes rather than reactive concerns about damage and things going backwards. And that is an important distinction to make. So that's the value we see in these new provisions.
Okay. Wouldn't it just be easier, though, just to say deterioration, restoration, it's all part of the same picture? What we need is deer management, nature restoration orders, and then that just encapsulates the whole thing, rather than having a quite outdated system based on preserving remnants of biodiversity and then trying to bolt on something that's more about restoration and improvement. It feels quite confused.
I think there is two parts to that, and I think the two parts are quite important in terms of, as set out, that the nature of deer management and the issue that we've got is pretty extensive throughout Scotland, a significant issue. So we are trying to make sure that we kind of get a baseline of effective and sustainable deer management across Scotland, and that preventing damage piece allows us to do that in a fairly clear and consistent way across Scotland in looking at the different habitats and purposes that we are looking to achieve in that. The second part of that is where we're looking to deliver that enhancement or restoration on a more specific basis, because we can't do that everywhere, but we are working at both ends of those spectrums to make sure that we are getting the best that we need for our biodiversity and climate on a localised or regional basis, but we are also working at that national level and that public, and that prevention of damage aspect is really important in that, to make sure that we get that consistency across Scotland.
Okay, thanks.
Just very briefly in a technical situation, when we're talking about Section 8, the bill suggests that a control scheme will be registered to the title of land. If that title was to change hands, should there not be something within the bill that would allow that control system to change back to a control agreement? Would that not be more reasonable, given that the new owners may be willing to put into place voluntary measures to control deer? Is that something we need to be aware of?
So an interesting question, Convener, and again how that would work in practice. I mean, the basic premise is that we want to ensure that control schemes persist, or that deer management measures persist regardless of changing ownership, and it's important that does remain the case. Now, how that would work in practice is that whether deer management provisions are carried out voluntarily or indeed as part of a control scheme, I don't think would make a lot of material difference. If a new owner was coming in and quite comfortable to apply the deer management provisions within a control scheme, it would make very little difference to them, actually. The risk is that they weren't able to deliver on those provisions, and actually Nature Scot would have to undertake the deer management arrangements and subsequently charge the owner, would be the issue. But if a new owner came in and was comfortable with the conditions of a scheme, I don't think it would make a lot of practical difference.
Maybe not practical difference, but surely a legal obligation under a control scheme is quite burdensome. And if a voluntary agreement could be made between Nature Scot and a new owner, that would be surely more proportionate.
And I suspect is absolutely negotiable, because as part of the control scheme we're reviewing on an annual basis, and we might reach the view that in that location and with that owner that a control scheme is no longer appropriate.
Okay, thank you. Donald, did you want to...
I think the point is that we are satisfied with the measures that are going to be in place. If we could be satisfied that the measures are in place, then that might negate the need for a continuance of the Section 8 control scheme.
Thank you. Emma Harper.
Thanks, Convener. Good morning to you. I know you've touched a little bit about the criteria for managing deer, and I'm just looking at different things here. There's different species of deer occupy the same habitat, and in the Nature Scot on the web here, it talks about the Deer Working Group recommended that Nature Scot adopted 10 red deer per kilometre square as an upper benchmark, but that's in the Highlands, and we know that there's deer in the borders in Dumfries and Galloway, and there's peri-urban deer as well. So I'm seeking to understand about deer management protocols or policies needing to be flexible, because there is different habitats that are occupied, farmland that is affected, so that's about damage to property rather than restoration in peatland areas, for instance, right? So I'm seeking to understand about how there needs to be flexibility on the bill, which then means that guidance can then be created that would work for the diverse habitat areas that need to be, I guess, protected and restored. Is that correct?
I think it is, yeah. There's no mention of specific density thresholds within this bill. I mean, I think it's incumbent on Nature Scot to take into account the size and density of deer populations in discharging our functions. And as you've rightly said, in different parts of the country, those densities will be different, the species will be different, and the impacts will be different. And I think it's important the committee understand and recognise that, because it is not a one-size-fits-all here, but what we need this regulation and this legislation to do is provide the flexibility for intervention based on different circumstances. And again, come back to Mark's previous question about damage. When we're talking about agricultural issues or commercial forestry issues, the biggest concern is actually about damage. And that could be coming from a range of species at various densities. And we just need to make sure that our interventions are alive to that fact. And indeed, if we are using Section 6 or Section 7 or Section 8 or Section 10, that it's afforded the flexibility to deal with site-specific circumstances, species and impacts. And I think this legislation provides that flexibility.
Baseline data will be collected and coordinated. So I'm assuming that Nature Scot will need to work with Forestry and Land Scotland, for instance, so that everybody is aware of how we're collecting the data and measuring or analysing, like a tipping point that requires a Section 8 or, you know, a level of damage that's been assessed. So that means partnership working in order to collect data. Is that correct as well?
Yes, so I mean, in the collection of data, there's a number of different facets to that around population, densities in localities, but also mainly around impacts around that. And as we said earlier, you know, most of the deer management in Scotland is done on a voluntary basis by private, third sector, public sector. FLS, a significant player in that, in that they take you know, a significant proportion of the deer kill every year. So yes, there's that stakeholder working across the piece, and the evidence piece in this and the collaborative nature of that, the sharing of that is really important. And we're doing quite a lot of work there to make sure that we've got the availability for that data to be made open and transparent, so that there can be more informed and better decisions taken across land holdings and within different management groups. And you know, we've got structures in the upland areas around deer management groups, but we equally need to get that kind of approach more apparent across other areas of Scotland.
Okay, thanks.
Thank you. Beatrice Wishart.
Thanks, Convener. Good morning. Looking at the limitation of criminal liability, Section 18 of the Bill amends Section 14 of the 96 Act, which deals with the criminal liability exemptions for actions under a control agreement, control scheme or Section 10 of the 96 Act. So are the distinctions between staff and non-staff criminal liability sufficiently clear under Section 18 of the Bill?
Yeah, I think what the bill does again is continue to clarify in pursuit of our functions under Section 8 and Section 10 that quite clearly Nature Scot staff or contractors who are working on our behalf are protected from potential criminal liability as expressed under 3A. So I'm quite comfortable, Beatrice, that this is practical and workable and is not a significant change from ensuring whoever, whether it's Nature Scot staff or contractors that we use, operate within the law.
And how will these changes be communicated then to your third-party contractors or indeed community groups?
Well, I think, again, in circumstances whereby we are exercising powers under Section 8 or Section 10, anybody involved in the control of deer, a lot of that will be spelled out in operational plans about the nature of the intervention, about what type of deer management provisions are being executed, about how they will be discharged operationally. Because again, just coming back down to it, a lot of that practically will be about what species of deer we're shooting, when, using what methods and where. So that will largely be captured in operational plans for delivering of those functions. How they're expressed to local communities, again, I suspect will depend on the nature of the intervention and at what scale. In pursuit of control schemes, for example, there is already a mechanism whereby we alert interested parties to the fact that a control scheme is in operation and the specific management measures which are expressed in it. And if there are any concerns about that, there's a means by which people can make representation, both to us and to ministers, about any concerns they have.
Yeah. Donald?
Yeah, I mean, so just to be clear, these are fairly limited and controlled circumstances where these will use. So they are highly controlled. What it does is you know, these may be circumstances where there is an agreement on the management that's taking place that might expose our staff who are undertaking regulatory functions to potential criticism around that, which may require, which may end up in you know, potential legal issues. Now, this provides an element of protection for our staff in that process, but it is limited and controlled, and clearly there are exemptions within that for welfare and other aspects of it which are completely important to maintain, but it provides that legal basis for our staff to be protected around some of those difficult circumstances where we might be putting boots on the ground to affect your culls, which might not be accepted.
Okay.
Thank you. We're going to move on to our next topic. Just, do you have any comment for the needs, or indeed the workability around any of the proposed changes to your investigatory powers under the sections 21, 22 and 23?
I mean, so it's basically looking at, again, at streamlining that so that we've got a more effective ability to enter onto land in circumstances where we've not got that agreement to take place. So, I mean, these were Deer Working Group recommendations that looked at this, so it's looked at an external body in extent to look at how it frees, it makes better use of our how more effective regulation can take place. So we're quite comfortable with that, really, in terms of making sure that that's in place and making sure that the availability of information and data that we might require to make decisions on those regulatory processes are available to us. So we're quite comfortable with that.
Okay, thanks. Next question from Eleanor.
Thanks, Convener, and good morning to the panel. I'm interested in understanding what processes NatureScot use to assess an applicant's competence and fitness to be authorised, especially if we think about higher risk activities such as using shotguns or night shooting. And also, I think it would be helpful for the committee to understand whether the bill will change this process in any meaningful way.
I'm happy to take that. So, I mean, fitness and competence is something that we deal with currently, so it's part of the process for issuing authorisations that we deal with. So there are two, and again, I think this was explained in the last session, but there's two parts. The fitness piece is around someone's ability to hold and own a firearm, and then the competence piece is generally about the practice, about being able to do that safely and effectively, looking at the various different, public safety, food safety aspects of it, and to do that competently. So that's the two bits that we look at there. And we apply that now in terms of looking at those authorisations that we issue. What the bill does is look to set that out in terms of looking at setting a kind of base standard for that for deer management across Scotland, which I think we are supportive of that in terms of demonstrating that deer management is done effectively, and there's a public confidence in that is important to make sure that the public are confident that we are able to those managing and killing deer are doing that competently. And then there's additional aspects of that which is linked to the other pieces in here about out-of-season control or night shooting, where we might look to put in additional aspects of training or requirements to make sure that that is done on a competent basis. So what the bill does is it allows us to look at that again in terms of competence and making sure that is fit for purpose in terms of modernising the different approaches that are available in Scotland now to use of technology for some of the management techniques that we've got. So making sure that we've got the checks and balance in there that provides that public and political confidence.
And if we think about Scotland as a whole in different areas, my colleague Emma Harper has already touched on that before, do we think that we have the necessary skills spread across the whole of Scotland in terms of people who possess those skills that we're looking for in terms of being able to do those activities? Or does Nature Scott believe that there's perhaps an area for how we actually help to train up and to provide assistance to people to get that level of competence?
So, I mean, we do have a significant resource in Scotland of people who are able to undertake effective deer management and culling. I think in delivering this approach around fit and competent, what we do not want to do is introduce unnecessary barriers there to make sure that we are not putting barriers in place. Clearly, we need to make sure that there is that public safety is at the heart of what we do, and we're not reducing standards in that, but we need to make sure that there isn't unnecessary barriers there to make sure that is the case. I mean, I think one of the challenges that we have for deer management is just making sure that we do have that continued resource coming through, and we will need that to affect the increased culls that we're looking at. I think, aligned with other agricultural and land use sectors, we've got quite a senior-aged population who are involved in doing this management, and what we need to make sure is that we do have a kind of flow of people coming into the industry around deer management to make sure that we do have that resource maintained in the long term. But I don't think that the competence element is a barrier to doing that. You know, it's inherent in most of the land management spheres now that we do have competence and training to do that. But it's important that we get that resource maintained and that there is, you know, an element of support there for that to take place.
I guess, yeah, I was just going to say my kind of issue that I'm trying to explore a little bit is perhaps if we think about lowland deer management and we think about the fact that you have a lot of people who will be asking permission as in a hobby kind of capacity to go out on land and help a landowner to manage deer. And the costs associated with that person getting to that level of competence can be quite prohibitive. So perhaps not thinking about larger estates in a more highland setting, thinking specifically maybe about lowland settings.
I think just in response, it's important again to remind the committee that we have got a wealth of skills and experience deer management practitioners in Scotland. Whilst that is the case, there is no requirement in law just now for anybody to have demonstrated their competence to go out and shoot deer. This is introducing a basic requirement of competence for anybody, you know, carrying a firearms to go out and demonstrate that they're able to shoot deer safely, humanely, with the highest regard to deer welfare, food standards and firearms safety. That applies to anybody who wants to shoot deer in Scotland. I actually think is a really sensible step to demonstrating confidence, actually, that deer management in Scotland is progressive, is operating to certain standards, and actually is much more aligned with what happens in lots of other European countries where there is a basic level of competence for anybody who wants to shoot deer. I think that's meaningful progress. I think there is a concern about that being a barrier to entrance, but in actual fact, when you look at the vast majority of vocational and recreational stalkers in Scotland who are all operating to excellent standards, most of them have already undertaken voluntary qualifications in order to be able to demonstrate that very point. So hopefully that dispels any concern that this is a barrier to deer management. But over and above that, where people are wanting to shoot deer out of season or at night, we already assess those individuals' level of competence, and we will need to reflect about how that happens and whether that provides opportunities again to ensure highest standards are being applied. And by doing so, it allows us to potentially deregulate the system, to allow those individuals who have got the skills and got the knowledge to be able to exercise those functions without recourse to coming to Nature Scott for a specific authorisation where they are already satisfied and have demonstrated they've got the skills and capacities to shoot deer safely and humanely with all active considerations to ecology and welfare.
Thank you.
Can I just, for clarification, will the authorisation be linked to properties or individuals, or will the ability be there to do to both?
Well, the ability will be there to do both in terms of the bill. Yeah.
Okay, thank you. Tim Eagle.
Yeah, just to carry on from that, if that's all right. So Section 28 of the bill allows people to register as authorised to carry out activities that require authorisation from Nature Scott. In what cases would one-off authorisations outside the register be granted?
So the suggestion is that activities, for example, driving deer with vehicles or shooting deer within the closed season, will still require specific authorisation from Nature Scott. So again, it's expressed under certain circumstances whereby once you're on the fit and competence register, you are able to shoot deer in Scotland. If you want to shoot deer, for example, at night, we would expect a slightly different degree of competence to be able to evidence and demonstrate that you can do that competently in line with what we already assess. That provides flexibility for those practitioners to make decisions about at what point during the day they want to shoot deer, in much the way the same they do when they're controlling foxes or other things at night. But there remains a degree of, there remains a requirement for specific authorisations to be applied by Nature Scott for certain activities, and those certain activities tend to be the exception, which are not normal and commonplace.
Okay, that's fine. Can I just then go back to, because I think Alina Witham's question there I thought was really good, because in the lowland context, we talk a lot about the upland context, we don't talk enough about the lowland context, which is much more problematic, I think. But if what we want to achieve is the reduction of deer numbers, effectively, for nature restoration, whatever it would be. We don't want barriers. So have you thought about, in terms of the fit and competence element, like some sort of what have I written down, a referee scheme or a grandfather rights type scheme that, at least in the interim, could help to help the sector to sort of officiate one another until they can get sort of whatever is official? I don't know. Do you know what that official thing will be?
No, so I think there's a bit of work, and we would want to develop that with the industry to make sure that we get that standards right for that. But in terms of the point there, I mean, those things are on the table. We have done that in the past. When we introduced fit and competence around that and the requirements for a level of confidence there, we did have almost that grandfather rights where we did allow people to sign, to have that basically demonstrate. Go to others to demonstrate that they have that competence there, as well as official qualifications. But I think the trajectory is that we do want to get that kind of official standards recognised, but the journey towards that, there will be a journey towards that, whatever that standards are. We just need to make sure that timescales for that and that people are prepared, so that we do not have that barriers. We cannot afford those barriers, but we do want to make sure that that competence level is maintained, enhanced going forward. But there's different ways of doing that, and the prescription around that, we need to make sure that it took that into account.
I think just again to put some colour on that, Tim, if I may, I suspect, and again I haven't quantified it, maybe I should go away and provide you with the data, that by far and away the majority of stalkers in Scotland will be DSE level 1 qualified already. Under those circumstances where there may be a proportion, it will be a small proportion of people who are not. Of course, we're happy to look at whether or not there's a means by which we want to continue to facilitate effective control, reassured by the right standards. As Donald said, traditionally we have done that with a system of 2 referees who are aware and have witnessed an individual discharging and demonstrating best practice. If there's consensus amongst the sector that that's something we need to actively consider, then obviously we're happy to look at it. But again, I think we want to ensure that we've got the right standards pitched at the right level, which has got consensus amongst practitioner groups, that we retain an ambition to make sure that those standards are right.
I do agree with that, actually. I think it's just making sure that there's no initial barriers. So I'm pleased that you are thinking about options, because we have got an incredible amount of talent out there, don't we? Some really experienced people. Just quickly, though, we've obviously got quite a lot of international guests that come across. I don't know if you can put on record yet or if you've thought about that, but I presume we might be able to do something along the sides of assuming they are accompanied by someone that is fit and competent by our law, that actually they would be allowed to come and not need to do any further stuff.
I mean, it is within the bill that will be permitted. So as long as they're accompanied by someone who's trained.
Cool. Can I move on to another question?
Yeah, just again for clarification. So, we talked about, Tim talked about the refereeing, Nature Scott effectively being able to authorise someone to be on the register that doesn't have DSC 1. Is that work that would be helpful, certainly for the committee, if we knew that work was starting now, so we would know what that transition to the new authorisation would be? Is that something you would take on now, a bit like the Code of Practice, start working that so the committee and the Parliament got confidence that we're actually not going to fall off a cliff edge?
We're happy to take that commitment away, Finlay, and put some thought into that, both in terms of process and timing. And again, just picking up on the final point from Tim Eagles there about guests coming from elsewhere. Scotland's got an international reputation for high quality stocking in Scotland and all of the benefits that provides locally. Indeed, quite a lot of those guests would already have secured qualifications from their own countries, which are probably at a standard greater than we're asking for in Scotland. But where they haven't, most of that would be addressed by accompanied stocking with somebody who is competent to do so.
How does that work in practice? Is that making sure your guest is within sight when they're shooting, or is that effectively what it means if you're accompanying a visitor, that you would need to be within earshot, eye shot, or whatever for that to be allowed?
Accompanied, yeah.
Yeah, okay. Thank you. Tim, I'm very conscious of time, and I've got Edward Mountain to come in. So, would you like to ask your final questions?
Just a couple, just final questions. The first one was around the BRIA, Business and Regulatory Impact Assessment. I haven't yet seen one or found one. Do you know if that's been done or is being done, and when we might see that?
I mean, that's something that's been done by the Scottish Government, not by ourselves. We've obviously contributed to that, but I don't know the answer to that.
Okay, fine. And the second one was just around legal resource, within NatureScot. I had a figure that the recent schedule one you did, the Lochroya estate, cost you nearly £14,000. Do you think, just for clarity, do you have the legal, if you're doing as many as the numbers we spoke about earlier, are you confident you've got the legal resource within NatureScot to actually deliver all of this?
I mean, is it one of the considerations that we take into account in terms of looking at the priorities and the work programme that we have, in terms of the resource that we have that? But I think, inevitably taking through that example was the first, as we've said already. So, there'll be lessons learned from that. So we wouldn't expect that to be the cost going forward of all of these schemes. So, yeah.
Okay, perfect. Thank you.
Thank you. Edward Mountain.
Thank you very much, Convener. Robbie, this question is going to come to you. I think between us, we've probably taken part or signed off the culling of several tens of thousands of red deer across Scotland. So just in a couple of sentences, bearing in mind the Deer Scotland Act 96 and this proposed bill, can you define what you think is good deer management?
So I think my immediate response to that, Edward, is planned and open and transparent. So decisions about deer management provisions are made in a very planned way, cognisant of actually some of the constraints provided by the land on which deer management is taking place.
That doesn't define it. It says what some of the constraints are. So let me try a definition and see if you can agree with it. The management of wild deer is part of a mosaic of species that affect the habitat in which they all live, to ensure the habitat as a whole is not degraded and the welfare of all affected herbivores are respected. How about that? Is that a good definition?
Well, you've given that more thought than I have in advance of the session. So yes, I think deer management decisions have got to be taken into account with habitat and land management objectives at their heart.
Well, you'd be surprised if I didn't think about deer management, which is what we're talking about, and I'm sure we would have all come prepared with that. So my question to you is, follow-on question for that. Is deer management forming a mosaic of species? For example, in Murray, in the low coast of Murray, it may be barley. In Abernethy, it may be capercaillie, if they're not declining too far. In the National Park, Gengors National Park, it may be Scots pine, if they're not being eaten by beaver. And on the west coast, it may be sessile oaks and the rainforest over there. All of these areas are zoned. Do you think there should be areas for zoning of deer, as Forestry Land Scotland do? Allow the greater numbers in certain areas and lesser numbers in areas where it is not appropriate to have them, i.e. new plantations. So do you agree with zoning?
I think inevitably zoning takes place already, Edward, based on the management objectives of the landowners. And I think that's absolutely right. As you well know, land management objectives are complex and varied, both within a place and between places. Deer management provisions need to be able to respond to that.
Okay, so if we're accepting zoning, what I want to know is how within the Natural Environment Bill, you will take into account zoning and accept some damage by deer in certain areas if there is not damage by deer in other areas. And that may be within a deer management group or, as you say, an individual estate, because to me the legislation doesn't allow for that. It's a bit of a sledgehammer to crack a nut. So can you explain to me how you will allow for that within Nature Scot?
Well, I'll have a first go and then maybe pass to Donald. But I think, based on the conversation we've had with committee today, there's an explicit recognition that we will intervene in certain circumstances in certain parts of the country based on certain triggers, which in actual fact probably already then recognises that in certain parts of the country we won't, and zoning therefore will take place as a result.
Donald, sorry, the convener can say whether you've got time, because I've got one follow-up question to it. So
no, I think the differential zoning or differential densities, as Robbie says, happens now, and that will continue to be the case based on the management objectives. But what we're saying, within the Act and within the bill that's going through now is that there's a need to prescribe more prescription on some of those areas to make sure that those objectives and outcomes are realised. But within Scotland and within the deer management areas, there will be differential density, there will be difference in management and ability to have those different objectives realised.
So, just turning specifically, if I may, convener, my last question to some activity carried out by Nature Scot on the North Ross Deer Management Group earlier this year, where they spent £32,000 providing helicopters to private estates to kill deer in difficult areas. Do you think that the deer habitat live in those difficult areas because it's the one area that they're not handed to day in and day out because they're difficult areas to get to? And do you think it's good management when you're doing that to allow only 21% of the hinds to be shot that are in calf, where for the last 5 years the average is about 40% of hinds shot in that area in calf? So you were definitely leaving calves on the hill. You weren't? You shook your head, Donald.
No, I don't think we were. I think that in those areas that they were targeting the deer is that it is in these circumstances the higher areas where there is they are less productive. So there's not the calving rates that you'd find in the lower areas in the North Ross Deer Management Group. But I mean, the staff, and to be fair, it was mainly estate stalkers who were involved in that. And doing the actual management, and they are absolutely bound by best practice in terms of making sure that there are no welfare issues associated with that, and that's at the heart of all the operations, whether it be helicopter or any other assisted culling.
It just seems a lot of money to give to private landowners to control deer when you're talking about Section 7 and Section 8 notices in other areas. £32,000 is a lot of money.
It's an illustration, actually, of a deer management agreement. It's voluntary. We've signed up to a voluntary agreement with a number of estates who are trying to discharge that. And we know, actually, that deer management practically is very, very difficult in terms of access of some of those areas. We worked with the estates to facilitate access, and it was a really good example, in my view, of collaborative action between the state and the estates who'd signed up to a voluntary control agreement.
Not sure I agree, but thank you very much, convener.
Thank you, Mr Mountain. And thank you, Robbie Kernahan and Donald Fraser, for your responses this morning. Very much appreciated. We'll now suspend this meeting until 10:25 to allow a changeover in panels. Thank you very much. I'll suspend this meeting. Welcome back. We are now joined by 9 stakeholders with an interest in deer management. I don't know whether that's a herd or a flock or a cacophony, or I don't know. But anyway, you're all very welcome. I will invite you all to introduce yourselves in just a moment. So we've allocated approximately 2 hours for the discussion, and as you could have seen from the previous panel, we have many questions to get through. Can I ask everybody to be succinct in their questions and their answers? And there will be some questions which will warrant no more than a yes or a no response. And I know that's incredibly difficult. But there will others that will need more of a discussion so we can hear the various voices. So could you please indicate to me or the clerks if you wish to participate at any point? And there's no expectation for everybody to speak to every point, especially if you feel that the point's already been made. Likewise, if you feel a part of the discussion doesn't relate to your area of expertise, don't feel that you need to respond to every question. And just to remind you, you don't need to operate your microphones. We have a gentleman that will do that for you. So I'm just going to start on my left and invite you to introduce yourselves. So Dick.
So that will be me. I'm Dick Playfair and I'm Secretary of the Scottish Venison Association.
I'm Duncan Orr-Ewing. I'm Head of Species and Land Management with RSPB Scotland, but here in my capacity as Chair or Convener of the Link Deer Group.
Grant Moore, Chief Executive, Cairngorms National Park Authority.
Tom Turnbull, Chair of the Association of Deer Management Groups.
Peter Clark, Scotland Director for the British Association for Shooting and Conservation.
Graham Press, Director of Land Management for Forestry and Land Scotland.
Alan MacDonald, Head of Nature Restoration at Trees for Life.
Ross Ewing, I'm one of the directors at Scottish Land and Estates.
And David Fleetwood, Director of Policy for the John Muir Trust.
Thank you very much. You're all very welcome. So I'm going to kick off. It's a question I asked Nature Scott in the first section. So Section 10 of the Bill amends Part 1 of the 1996 Act, adding the public interest to the aims and purposes of deer management and the environment as something Nature Scott should take account of when carrying out its functions. So the question is there consensus on the terms public interest and environment and how they relate to deer management across the sector? Ross.
Thank you, Convener. Good morning, Committee. So I think on this point it's important to understand what actually aims and purposes mean in the context of the 1996 Act. So Nature Scott have to have basically regard to these aims and purposes when exercising their statutory functions. And I think the one that kind of feels out of kilter with the rest is the one around safeguarding the public interest, insofar as it's not a term that's actually defined in the bill. There was, as you mentioned, Convener, in the previous session, an attempt to define it in the explanatory notes, but with the absence of a definition on the face of the bill, and given that there's a direct correlation between the aims and purposes set out in the Act and Nature Scott exercising their statutory powers, which in the worst case could include a Section 8, we feel that the absence of a definition here is limited. You also mentioned there the addition of the word environment, and that comes later on in the section. It talks about the size and density of the deer population and its impact on the natural heritage and environment, so the environment being the addition. The rationale for this is set out in the explanatory notes, and apparently it's all about Nature Scott being able to take into account the cumulative impact of deer across Scotland when considering and formulating deer management policy. But we know, because Nature Scott have also admitted to us on the record, that actually, ultimately, whatever the national deer population size or the size of populations of each deer species, of much greater significance are the impacts of deer on their environment at local and regional scales. So the cumulative impact of deer across Scotland, per the explanatory notes, is somewhat inconsequential in our view, so we feel it's probably a bit of an overreach, and we're not convinced, certainly, by the rationale set out in the explanatory notes, Convener.
Okay, thank you. Duncan.
Yeah, so I think this will come later. We're satisfied that this public interest definition will come out in the discussions around the Deer Code in due course. I mean, we're dealing with legislation that dates back to 1996 here, and as explained by Nature Scott at those times, you know, the main priorities were around protection of forestry and agriculture. I mean, we are now dealing with climate and nature emergency, needing to restore biodiversity at a landscape scale, and, you know, many of the drivers of nature restoration, peatland restoration, new native woodland plantations, I think all of that will come out in the Deer Code, but along with ADMG, we do think it will be helpful to have some case studies of what good looks like in practice.
In due course, Before I became an MSP, Sir Alec Ferguson, the late Sir Alec Ferguson, said that deer was something I should avoid in Parliament, but surely they'll have it sorted out. That's, you know, it's many years now. So when you say in due course, should we not be seeing that clearly set out in the Code of Practice now, in tandem with this bill going through, rather than waiting until it's an act?
Yeah, I mean, we've been through the process, as was mentioned earlier, of developing the grouse code. We've been also involved currently in the Muirburn Code. You know, these things are worked up with full stakeholder involvement. I mean, we're quite satisfied with those processes, and that will ensure that, you know, a fair definition of public interest is arrived at.
Okay, thank you. Tom.
Thank you. Managing deer in the public interest is something that we've been asked to do for quite a long time. Still something that's very difficult to define. In fact, it was so difficult to define that when we were assessed, there were 101 criteria that the deer management groups were assessed on how we're managing deer in the public interest. And we did demonstrate considerable progress in exactly that. So there are deer management plans in place. We're aware of what's being planted. We're aware of peatland restoration that's being done. We're aware of the work that's being undertaken. We're aware of the deer that are being shot. We're aware of the deer that are in the landscape, in the highlands. And I think that we're already managing deer in the public interest. I think a definition would be helpful, but we are already doing that in the highlands. I think what we should be doing is furthering and not promoting sustainable deer management. We should be providing a resilient deer sector with deer managers that are capable of managing the deer in the public interest, however that's defined.
Thank you. Peter.
Yes, so obviously there's consensus around the room about effective deer management, and obviously it differs depending on who you are, the pathway that you take to get to that. I think with regulation we need to see further incentivisation, and particularly on the public interest point. We've heard through various different aspects of farming, public goods, public money. I think that absolutely needs to follow this bill. There needs to be greater incentivisation to drive the change, because at the moment the financial package is not there, and it becomes regulation over incentivisation at the moment.
Okay. Grant?
Just very briefly on this point, I would just say that public interest, whether it's in the legislation, whether it's in the code, I suppose my point is that having it in the code then allows you to change as things change over time. Having it in primary legislation tends to tie things down for a long time. And I think, as we've seen over the past 10, 15 years, public interest has changed when it comes to land in terms of what that is. So I think having something that's in the code makes more sense, but also having an understanding of what that might mean as we go along is probably something that's needed. So I think it is trying to do some early work on that with stakeholders is a good thing to do, and I think that's something that should be looked at.
Can I ask you just on that, do you think, in your view, would it be better if we saw a draft code of practice prior to the conclusion of this bill process?
I don't know exactly around the timescales about that in terms of Nature Scotland capacity and such like. I think, though, that in terms of discussions with stakeholders around what that public interest looks like, and to have some initial discussions so that people are clear about where that is heading, I think would be useful.
Graeme?
Yeah, just I'm trying to be succinct. I support what's been said, and the fact that we manage, as we all know, around the room, 9% of Scotland, 30% of the deer cull, and our experience is, is confirmed. I agree what others have said, and it's not helpful, I think, to define too tightly public interest. If you look at that experience, having it in there is important, and I think having environment is important because it recognises the nature and climate emergency.
Okay, thank you. Ross, want to come in again?
These aims and purposes are really, really important. It's part one of the bill. It's where everything kind of stems from, if you like. And I think for that reason, it is really important that a definition is provided. Whether it's on the face of the bill or whether it's in the code is somewhat inconsequential. But at the moment, there's no obligation for that definition to be provided in the code. So if we're looking at amendments at stage 2, that is certainly something that we would quite like to see in there to ensure that definition is provided and potentially changed in due course. But we would certainly support having the code of practice developed now ahead of stage 3 for the kind of reasons of clarity that you set out in the previous session.
Okay, thank you. Beatrice Wishart.
Thank you, Convener, and taking you at your word, it will be a short and succinct question. Do you agree with the proposed changes to advisory panels and the code of practice on deer management? Who wants to take that?
Thank you, Convener, and thanks for the question, Beatrice. So the function of advisory panels are set out in Section 4, Part 1 of the 1996 Act. It talks about encouraging and facilitating the engagement of the local community in deer management, looking into issues relating to deer management in the locality, and communicating the views of the local community to those engaged in deer management. The thing that we are not really clear on is why Nature Scott want to be a formal part of the advisory panel and what they were being limited by just being someone that observes an advisory panel. And that's not really clear reading through the explanatory notes or the policy memorandum of the bill. So if it would be possible to get some clarity from that from Nature Scott as to why they feel like it's important for them to be a substantive part of the advisory panel, that would be helpful. The other point I thought it would just be worthwhile touching on, Convener, is that Nature Scott is the entity that convenes these panels, and I suppose is there a question around kind of conflicts of interest? If it's convening it, does it also have the right to be on the advisory panel in a substantive way? So it's more procedural, but at this point in time, we are not clear for what reason Nature Scott are seeking to be a substantive member of advisory panels as opposed to just an observer.
I think absolutely on that point, I think it's just clarity of why Nature Scott would like to be on that panel and why they wouldn't want to have some form of independence from a panel going forward, maybe on an advisory capacity.
Okay, thank you. David.
Thanks, Convener. Good morning, committee. I agree with the point on clarity. I think we'd support the changes, and I wonder whether there's something in there, and perhaps for something for SNH to come back on the difference sitting as an active part and taking an active part in decision making rather than an observer to proceedings. And I think it's on that basis that we support that change.
Okay. Hey, Alan. Yeah, sorry, beg your pardon.
Yeah, hi everybody. Yeah, just would note there's a wide variety of expertise within Nature Scott. It just makes sense for decisions to have access to that across a whole range of specialisms within the agency. I think that makes a lot of sense. And then as for the code you asked about, I think the importance there is everybody's interested in clarity to know how that's where we're going to see how this legislation will work in practice. Without that, we will have uncertainty. Without uncertainty, we'll have fears of different agendas. That's going to fuel division. That's literally that's a practical obstruction on progress on the ground.
Okay, thank you. We're going to move on to our second theme, which is deer management plans, control agreements and control schemes. And we'll kick off with a question from Mark Ruskell.
Yes, so we're interested in those sections of the bill which relate to deer management. As the convener said, you know, the plans, the control agreements, the schemes, and I think the aspects we're interested in your comments on are particularly incorporation nature restoration as a ground for intervention. We've already discussed that in the earlier panel. The proposed changes to the control measures, and also Nature Scott's ability to recover the expanded costs. So, I don't know if Mr. O'Ewing, I think, would like to go first.
Yeah, so I have to express at this time my concern arising from the Nature Scott evidence that we've just heard. I mean, for me, that did not show the ambition that is needed. We're in a climate and nature emergency. To me, it sounded a lot like business as usual, constrained by existing resources. I mean, just to remind everybody, we have a context of a population of 1 million deer and increasing. We know that we're being asked to increase the deer cull by 50,000 animals per annum to get us on a downward trajectory in terms of the national deer population and reduce the damage, facilitate nature restoration. Many of us out on the ground, and I don't just speak for NGOs here, but also for, you know, there are private landowners, there are public bodies trying to deliver nature restoration on the ground and are often frustrated in that exercise by, you know, pressure from deer, often coming from outside the boundaries. Agree with the commentary we heard earlier from Tim Eagle, Emma Roddick and others around this room that we need, you know, clarity around what Nature Scott must do and the triggers when they have to intervene. At the moment, that is not clear, and I think there should be more occasions. I mean, the Independent Deer Working Group report, for example, set a threshold of 10 deer per square kilometre. Surely that should be a, must intervene type trigger, but also when it comes to protected areas, which are a fundamental plank of nature restoration, we need these areas in good condition, and many are degraded through damage by herbivore browsing. and trampling, that's woodland and upland sites mainly. We need more action on the ground, and it didn't sound from Nature Scott like more action was coming. It sounded like they're roughly going to do what they're currently doing. That's not enough.
Thank you. Grant.
And I think this is the key part of the bill really is this part around these interventions and how you intervene. And I think it's really crucial that we get that right. And I think one of the things that's interesting to me is how it does link to plans, because one of the things that it talks about in the bill is the need for these powers to be linked to then plans that are put in place to do things in certain places. And under other bits of legislation, we're seeing plans coming through. So things like under the Planning Bill, all local authorities through their local development plans, including the National Park authorities, have to produce nature network plans for their areas. So the question is, if you've got a plan that says this is your nature networks for certain things within areas, and you have something like deer management preventing the delivery of those nature networks, is that a grounds for intervention? Now, it might be at a voluntary level to start with and working up that hierarchy as Nature Scott described, but I think it's really crucial that we understand where the interventions are and at what scale and at what the resources are that are needed to do those things, because it's the resources side of things that I think is one of the crucial bits to this. Is it's all very well having legislation, but are you then able to do the things that you want to do within that? I think the key thing for me is this move away from just looking at damage to degraded landscapes, because if we're going to reverse biodiversity loss, if we're going to actually tackle the nature crisis and the climate crisis, it's not just about if you like, stopping damage to what are already degraded systems. It's about trying to actually say how can we make the enhancements to deliver in these places. Now, a lot of that will be on a voluntary basis. There's no doubt of that at all, because a lot of that work is done on a voluntary basis currently. But there are places where we will need intervention, and trying to make sure we've got the right mechanisms for that. So that is then saying, what are the plans that trigger those things? What are the things that actually make intervention happen? And do we have the resources to be able to do that?
Okay. I have now got David.
Thank you, Convener. I agree with the points that have been made. Perhaps add a little bit more data to some of those. And as Grant was articulating, I think this is one of the key points of the bill. And we just talked about delivering deer management in the public interest and the definition of that. I think it would be fairly uncontroversial to say that would incorporate the definition of public interest, responding to the climate and biodiversity crisis, flood mitigation, increasing water and air quality, etc. And if we think about a situation where we've got 80% of peatland degraded, native woodland cover stagnating at around 3%, deer counts by Nature Scott showing 56% of areas surveyed having densities above 7 per square kilometre, at which point we're seeing deer damage to native woodland and to peatland. Only 4% of surveyed sites with densities at 2 per square kilometre, which is the level at which some of that habitat is going to regenerate then. For me, that's a pretty good illustration of why that shift from damage and protecting a degraded baseline to something about moving forwards to restore some of that is critical to the bill.
Okay, Ross.
Convener, at this point in time, I am not able to say to the members who I represent in what circumstances they will be subject to regulation, because that clarity is not provided on the face of this bill. Now, it's all very well to discharge that to the Code of Practice, which we know is the intention of ministers. But actually, if you look at what Nature Scott have to do in relation to that Code of Practice, it is by no means clear and definitive enough. So, as you touched on in the last session, Nature Scott have to have regard to the Code. This is what to have regard to the Code means. It means to have regard to a matter means simply that the matter must be specifically considered, not that it must be given greater weight than other matters, certainly not that it is some sort of trump card. It does not impose a presumption in favour of a particular result or duty to achieve that result. In these circumstances of the case, other matters may outweigh in the balance of decision-making. On careful consideration, the matter will be given little, if any, weight. In this circumstance, that means that whatever is set out in the Code of Practice, Nature Scott they just need to consider it, but then they could act in complete contravention of it. That is the reality of what we're talking about. So when I'm trying to give members certainty about the circumstances in which the state might intervene in deer management issues, even when this code is finalised based on the current draft of this bill, I will be unable to do that. And I think from a pointing around of this legislation being reasonable and proportionate, I just can't see how that complies. The other compounding issue with this is that we don't yet have a business and regulatory impact assessment, and to our knowledge, we've certainly not been approached by NatureScot or officials to actually understand how these powers might impact on our members under this new ground for intervention. I don't think my colleagues at the ADMG have had a similar representation either. So I'm not clear at this point in time whether there has been any assessment undertaken as to the actual real-life impact on this. All we have is the financial memorandum, which sets out some arbitrary numbers, about 3 to 5 deer management plans going forward, 9 control agreements a year, and up maximum of 1 to 2 control schemes going forward under this new ground. How those numbers were determined without actually having the criteria and the circumstances decided is beyond us. And at this point in time, I have to put on the record our serious concern about the new ground for intervention and how that's going to interact with NatureScot's statutory functions.
Okay, I've got Tom, Peter, Graham and Alan, but I think David wanted to come in on a point that you raised, Ross.
Yeah, thank you, Convener. I was going to agree with Ross about the opportunity for clarification here in terms of process and timelines, and I think there's also something that we might come back to discuss in terms of creating some clearer triggers for NatureScot to take action under Section 7 and Section 8. There's a variety of ways you could do that. Deer densities over a certain level, damaged or deer densities around designated sites, sensitive habitats being negatively impacted, etc. So there's a substantive discussion to have on what those triggers might be. But yeah, I think agree that there's an opportunity for clarity here that would be usefully taken.
Okay, Tom.
Yeah, just responding to something you said earlier, the million deer in Scotland figure, which is bandied around quite regularly. There's no evidence of how many deer there are in Scotland. We don't know. We don't know how many are being culled currently either. We know roughly what's happening in the Highlands, but out with that we know almost nothing. And when it comes to the triggers for intervention, I believe that to demonstrate that there has been restoration or enhancement, you will still have to demonstrate damage. So we're talking about effectively the same thing, in my opinion. I think we need clarity, as has already been called for. I think we need case studies, as was mentioned in the previous sessions. I think we need reassurance for a sector that's feeling pretty demotivated in the Highlands at the moment. We've got a lot of very skilled practitioners out there who work hard in very difficult conditions to deliver culls. And I think we need to reassure them that their futures are safe, and I think we need to make sure that the deer managers of the future are in place going forward and they're enthused as well. I think if used incorrectly, we've already heard about the voluntary principle in terms of deer management in Scotland. I think if used incorrectly, these triggers could perhaps have a very negative effect on voluntary collaborative deer management. Why would you put a target on your back? By collaborating with NatureScot, with providing them with figures, if you are then going to be regulated on what are very unclear currently grounds. It's a big risk, particularly for my organisation. And going forward, I think there needs to be real support. Every other rural sector has incentives. Where are the incentives for deer management? Where's the support for deer management going forward? All of this is required if these triggers are going to be used going forward, I think, in that transition.
Thank you. Peter.
Yes, I think going back to this bill, obviously we saw in the consultation the draconian measures proposed in the so-called deer management nature restoration orders. And a lot of those powers have just been rebadged and included within this bill. And of particular concern to BAS members is that vague definition of nature restoration. Herbivore damage varies widely on different areas of Scotland, and pinning it purely on deer is going to cause significant issues, and also faces significant challenge for landowners and deer managers indeed. I think also the complete lack of baseline criteria it's a serious issue as well. It leaves a lot of the decision making on the imposition of Section 6ZB entirely down to NatureScot discretion, and that is very worrying for our members indeed.
Okay, thank you. Graham.
Okay, yeah, I've got 5 different points to. I've been gathering them up as we've been going through.
I'm sure there'll be 5 succinct points.
I'm going to be succinct, though. I'm going to be succinct. So, first one, if a number of people around the table, is the step change required. We can argue about the exact numbers, but broadly speaking, the deer population has doubled in Scotland in the last 30 years. And if you look at the impacts, we all know Scotland is one of the most nature-depleted countries in the world. So these are sort of really, that gives a good, in terms of baseline. So I think baseline is really important. And that point about nature restoration, this being the core of the legislation, to go beyond damage to what's there now, which is often degraded, to actually restoring. And unless we do that, we're not going to achieve our targets in biodiversity and climate. So they are really, really critical. If you look at ourselves, Forestland Scotland, we manage 9% of Scotland. We do about 1/3 of the cull. But, you know, hands up, we've not got it right everywhere ourselves. We've not got deer densities down to levels that are required to achieve all the objectives. Partly we need to do more, partly it's incursion from neighbours. So it tells the scale of the task. I think it's important to bear that in mind, and that need for a real step change. I agree with the point of having clarity around triggers for intervention, but that's got to shift from what are the current triggers under the current legislation. Otherwise, we'll not see that step change. 2 other points I'll mention is authorisations, just really for information. It's mentioned in your question there, Mark, is that we've used authorisations for a good number of years now. They've been critical to achieving the level of cull that we do in terms of night shooting out of season, and we do that in a very safe, careful way. But they're really critical to achieve as part of that step up from our own direct experience. My final point is around there's really a need for some emergency measure here. If you get an incursion, say after snow in winter time, and you're doing new woodlands or you're doing restoration, if you get an incursion, that can be set back overnight. So having a measure in the legislation that allows for that action promptly, quickly in an emergency situation is really important.
Okay, as the Chair, I've got a difficulty here. Everybody's indicating to come in, so I've got some first-time speakers, but I know Tom wanted to challenge, I think, from your expression and your indicating something that Graham said. Do you want to come in, and then I'll move to Alan?
It's another one, this doubling deer population. I'm not sure we know that. We know roughly what's happening in the Highlands. There are helicopter counts on the open hill. You can tell what's happening out with that. Do we know that? We don't know what the cull is.
Okay. On that point,
the 1 million deer population is on the official record. It has been publicly stated by Scottish Government and Nature Scot. So that is there to be seen.
I've said that figure is misleading and unhelpful, and you've used it in this evidence session, Mr. Roy-Ewing, and the previous one, and I think we should heed Nature Scot's advice on this, but I'll leave the matter at that.
Okay, thank you. Alan.
Well, I just want to talk about the echo Graham's point about the step change, and the trigger should match that, and that we can have, in terms of agree with the need for clarity, but our ambition needs to be set around strategic objectives. So we're talking about Scottish Biodiversity Strategy objectives for 2030 and 2045. But I particularly want to mention that we do have the means of providing that clarity. So with data sets we already hold, we can prioritise where the greatest opportunities are for nature restoration at scale. And we have the ability, I mean, Nature Scot has been assessing and comparing the current condition of habitats with restored condition for about 30 years now. And we have the techniques to assess what the impacts of herbivores are and the contribution of herbivores, for good and bad, within that. So we can set these objectives, and therefore that clarity that can come through the Deer Code and how that works to be co-developed within the sector, I think, is really important. And that in turn can then inform, you know, a number of people have said already. Tom was making the point clearly, we need the resources to implement that on the ground. And work has already sort of started in terms of, you know, we've collected some data, a colleague of mine, what's the average cost of this kind of reduction in deer population, the benefits that can come from that in terms of the sheer scale of woodland that could be regenerated, for instance. And there's interest under banner of the Common Ground Forum and kind of discussing that right across the sector. Tom and I were talking about this morning. So I think there are the means. There's a need to go forward, and there's the means to take it forward.
Okay. I'm aware we're now getting second time speakers on this first question. I'm going to bring in, I've got supplementaries from a number of members as well, so I'm going to bring in Emma Roddick with her supplementary. I'll go through the list again and feel free to add your comments if they weren't covered previously. Emma.
Thank you. This is kind of a sidestep, but I wanted to ask David about John Muir Trust's submissions so far around funding for fencing and the value for money of that compared to tree planting for woodland creation, if you could speak to that.
Yeah, thank you for the question. Picks up the point Alan was just making too, and some of the discussion we've just had around incentivising the kind of step change that we've all talked about. I think the numbers that we've put forward, and I won't go into the kind of fine detail for time, but would allow effectively the Scottish Government to incentivise and provide the finance for a significant proportion of that additional cull, whilst at the same time delivering natural regeneration of native woodland, and using some of the funding that is put forwards to support woodland planting, diverting that into deer management gives you the opportunity to potentially solve two problems with one investment. Graham might wish to come back on this. So I think what we've looked at is the opportunity to use something like the Forestry Grants Scheme in a slightly broader way. But yeah, I'll leave it for others to come in.
So, bring in Graham and then Alan.
Yeah, so Scottish Forestry aren't here, but I know where they are on that, and Brendan was at a previous committee meeting covering this. So there is an interest in Scottish forestry. There's something like £8 or £9 million a year spent on fencing through forestry grant schemes, and there's definitely an interest in at least some of that being moved towards more effective deer management, recognising, picking up my earlier point, you only need one break in a fence, and if you've got a high deer population next door, you can lose all the good work. So fencing has got its place, but there is significant downsides in terms of cost and longevity, and securing in the longer term new woodland creation. And also, basically, if you've got the deer numbers down, of course you get good, if you've got seed trees, good natural regeneration, and of course that's cheaper than cultivating and planting trees. So.
Yeah, just as my colleague helped put some of that data together, so I'm happy to write to the committee with some more detail on that, because it might be of interest. Just also to note that the kind of total budget probably falls within current grant schemes already dedicated to nature outcomes, and we think would be more effective than them. And also that in funding it the way it goes, the way we'd say that going, is that would directly help secure deer management livelihoods for the long term. Just key to going forward.
David wants to come back on this particular point.
And Alan will probably also cover with some of the follow-up, but just to give an illustration of some of the figures. Deer fencing, average costs of 150 million a year, a national cull programme, potential cost 35 million a year, and restricting that to the additional deer numbers above the existing kind of cull rates, 1.5 million a year. So a fairly significant magnitude in terms of difference in cost and potential public savings that you could levy from that approach.
Okay, on this particular point, anybody else want to come in on this particular point? Tom?
Just to say that we would be supportive of a scheme that promotes a cull and supports a cull going forward. There will be a long time scale required for recovery in a lot of areas. It takes a long time for land to recover in a lot of places. And I wouldn't preclude deer fencing from the conversation. It's a useful tool, but it does have to be kept upright to be used. And stock fencing will also be required in many circumstances as well.
On this point, Peter.
Yeah, I'll be very quick. If we're talking about the total cost of deer management and the pressure on the taxpayer, BASC's long advocated for community integrated deer management, where you use recreational local stockers on public lowland land, and that brings down the contract bill. So that would be one other option that we could pursue, and a missed opportunity in this bill, actually.
And Duncan.
Yeah, I mean, just to say that obviously there's 3 trials going on at the moment across Scotland. There's one in the Cairngorms, one on the side of Loch Ness, and one down in the Central Belt, looking at different ways of incentivising around deer stuff. Obviously, we've just had the first year, we're about to go in the second year, it's quite early, but I think there's some interesting stuff already coming out of those trials in terms of how we can help to incentivise the right things. Just wanted to pick up one other point around the fencing side of things. I think we've got to, there's quite an interesting discussion around that, around one-off costs versus recurring costs, and the outcomes and the benefits you get from different things in different ways, which means that you might be able to maintain employment in certain places with ongoing recurring costs, but it might cost you more in the long run to do those things. So it's trying to find the balance, I think, between those things. Obviously, we want to see as much done as possible without deer fences and natural regeneration. However, there will be places where fencing and planting make sense as well. So we've got to be a bit careful we don't sort of just say it's one thing or the other. It's trying to find the right balance and the right places associated with that. And just to pick up one other thing, which was that somebody said it's, yeah, I think it was maybe Peter talked about not just pushing on deer, and I think it is crucial we think about this in terms of integrated land management, which is, we're talking about deer today, that's great, but in certain places it will be the mixture of other herbivores on those landscapes as well. And we've got to take account of that. We've got to think about those things, because there's not much point in taking down, you know, reducing deer substantially in a place to reduce damage or overgrazing, if at the same time you're not looking at any of the other herbivores on that, including sheep and other things in certain places. So we've got to think about those things together, and I think that's really crucial. And ultimately, most of these issues where we get into some tricky things are usually on boundary issues between estates or places that are looking to reduce numbers versus estates that are looking to maintain numbers at a certain level. And the question is, who is it that is responsible then for who to put the onus on to do the thing associated with deer? So at the moment, the onus is on the person who's wanting to reduce deer numbers to keep those deer numbers out. There's no onus on the person who wants to have high deer numbers to do anything other than maintain high deer numbers. So there's a little bit of thinking there about when it comes to the Nature Scot interventions as to where you do that, and that boundary issue is expanding all the time because land management is changing all the time in terms of Scotland.
Duncan.
Yeah, I was just going to build on Alan's point about nature restoration. I agree with everything Alan said there in terms of we know how to measure this, what good looks like. We've got plenty of exemplars now of what nature restoration best practice looks like, including some delivered by Nature Scot at Craigmeggy, Ben A, there's Abernethy, our own site. There are a whole range of these, both in the uplands and lowland deer range now, which we can draw upon. I do agree with the incentives point as well. We do need to incentivise deer management. That's a key discussion. I just wanted to touch very briefly as well on the voluntary approach, which Nature Scot also mentioned. So, I mean, for me, at the moment, the voluntary approach has been given a fair wind, and it has not worked enough. I mean, some of the best practice examples that we've got have not been delivered. Of nature restoration have not been delivered actually through the deer management group structure. They've been delivered by, you know, like-minded bodies coming together. I mean, the Cairngorms Connect project being a good example of that. You know, we do need clarity over when Nature Scot must intervene in the public interest. And as Graham said, you know, when you're doing nature restoration, a lot of good work can be done overnight unless you've got rapid intervention powers. From, you know, these are deer incursions coming in, damaging peatlands, native woodland plantations. We do need the facility for Nature Scot to take action in those circumstances and quickly. So if a community or an ENGO or a private landowner asks for help, we need a swift response from Nature Scot or a good reason why they can't come in and help.
Okay, on this point.
Yes, Convener. So just in relation to the point that was raised around the voluntary principle. So the voluntary principle does work in the vast majority of cases, and that is actually reflected in what we're dealing with here, because 6ZB, this new ground for intervention, was not recommended by the Deer Working Group report, and I think that's a really important point to highlight. So the Deer Working Group report was asked to make recommendations for changes to ensure effective deer management in Scotland that safeguards the public interest, and no such recommendation around this new grounds for intervention was raised. And the argument that's been put to us by ministers on this is that, oh, well, we didn't have a nature and climate crisis at that point, but at that point in time, we had not one but two biodiversity strategies already in place. So to say that the Deer Working Group would not have considered biodiversity loss, the biodiversity crisis, in the context of coming to its recommendations is not correct. And I think this power, I think the really important point for the committee to note in respect of this is this is not followed from the recommendations of the Deer Working Group report, which put 99 recommendations and 350 pages together for ministers to consider. And I think that's a reflection of the fact that in the vast majority of cases, the voluntary principle does work.
Final comment on this topic, David.
Thank you, Convener. I think the premise of some of Mr Ewing's point is that the current system works, and I think I would contend that's potentially not the case. We've seen a number of Section 7s not achieving their objectives. We've got examples on land that we manage in Assynt, impacted by neighbours refusing to engage with NatureScot to develop a control agreement. Of the 11 implemented across the country, we've seen one achieve its aims, one Section 8 order implemented in all this time just in the last year. So there is something about the current system that isn't functional. So it's right that we look at it through this bill.
Short right to reply.
To the point, which is we're not saying that the powers don't need to be changed. They absolutely do need to be tweaked to make them more effective and usable. What we're saying is this new ground for intervention is not evidenced in the piece of work that ultimately preempted all of the changes we see in this bill. It's the one thing, it's the pariah in all of this. It was not recommended by the Deer Working Group report.
Tom, before the next question.
Yeah, I think I just need to respond on Deer Management Groups, as that is my remit. It's the only area, the Deer Management Group area, in the whole of the UK where we know what deer numbers there are, we know that they are static or declining, and we know what cull projections are going forward, and we agree those with NatureScot. Nowhere else in the UK do we have those figures. Anywhere. We have it for 3 million hectares of the Highlands, and we should be proud of that.
OK, I've got 3 members with supplementaries on this topic, and I start with Tim Eagle.
Yeah, it's quite just one very niche point. In the previous session, you heard us just ask a couple of quick questions around a situation where a control scheme is in place and the land is being sold and what the impact of that could be. Now, that's pretty niche. I imagine that's not going to come up very much, but does anybody have any comments on whether they think that's the right approach or not?
Ross and then Duncan.
Thank you, Convener, and thanks for the question, Mr Eagle. So, yeah, I think in that sort of situation, and it was kind of sort of reassuring to hear some of NatureScot's commentary on this, I think the right approach, if the new owner of the landholding is willing to manage and to get on top of the deer after a Section 8 had been in force, I think our expectation would be that NatureScot would de-escalate in that circumstance and get a voluntary control agreement in place, and I think that would be the reasonable and proportionate thing to do. But I think it's important that we acknowledge that applying Section 8 to the title of the land will have other unintended consequences in terms of land value, land marketability, and I think these points haven't really been addressed. I'd expect the business and regulatory impact assessment to look at this, but we haven't seen that yet, and if it doesn't, I think there'll be some questions around whether the general principles as a whole could be supported.
I've got Duncan and Peter.
When it comes to nature restoration, as Tom was alluding to earlier, in some places, particularly the west of Scotland, you know, where the climate and conditions are such, it can be a long-term process. So you need to transfer this across, you know, the requirement to reduce deer numbers and maintain them at appropriate levels over a long period of time. So I would suggest, yes, this does need to transfer to successors in title.
OK. Tim, did you want to come back?
I suppose just on that point, though, I guess it's a point of overreaching, isn't it? So actually, it's not that we want the impacts of the Section 8 or whatever it would be to not to be adhered to, but if the new owner coming in is saying, yeah, I agree with all of that, then actually for the process of that land sale, actually, because the land prices could be affected, should it be on the face of the bill that actually in that situation NatureScot can de-escalate that to an agreement rather than that land being sold with a control scheme in place? Does that make sense?
Yeah, it does make sense, but for me it has to be a cast iron commitment that from the new purchaser of the land that they will continue whatever has been requested by NatureScot.
OK, thank you. Emma Harper.
I don't know if my question is just going to take us back or not, but I'm thinking about what we were saying about we don't have the numbers accurately that reflect the deer population, and Duncan said that it was 10 deer per metre kilometre square, right? But that's actually red deer. So, and Tom was talking about we don't have accurate numbers. We do somewhat in the Highlands. But I'm thinking about like deer damage and restoration is where we're measuring what we need to do in terms of action, and then there's all the different deer types of species. So does it really matter that we have accurate data if we're measuring it, looking at interventions based on damage or restoration requirement?
Ross and Alan.
Yeah, we've been trying to move away from this frustrating conversation around deer densities and numbers for quite a long time, because it's something that's unhelpful. I mean, even a deer density is a snapshot of a day. When a count has taken place, those deer might be in a completely different place the next day. So it's not necessarily most helpful. We've been, since the start of the assessment process that we went through from 2014 onwards, we've been encouraging members to undertake habitat impact assessments to measure exactly that, what is happening on the ground. And that does measure damage. I don't know how we're going to measure restoration and enhancement going forward, or encourage our members to do that, but presumably that's something that will be looked at within the code.
Thank you. Ross.
It's a really good point that you've raised, Ms Harper, because actually this power is going to be underpinned to some extent by the availability of good data. We have relatively good data, certainly within deer management groups, who are not just culling deer, but they're also delivering really good things like peatland restoration, habitat restoration, and so on. So the question then follows is, how do you apply something like Section 6ZB to the lowlands in Scotland? I don't think it's possible to do it, because there's not suitable data. You've got a vast number of different land holdings, all of whom, or quite a lot of whom, will rely on recreational stalkers, not professional deer stalkers. What we've created here is a regulatory scheme that is basically only applicable, really, to the upland context, where actually we're probably having the best go at managing deer in a sustainable way. There's parts of lowland Scotland where that collaboration does not exist, and all of this, as I say, is underpinned to some extent by data. So the lack of data in the lowlands, I think, is going to make these powers that we're talking about here really difficult. It's why NatureScot conventionally have not really used their statutory powers in a lowland context. This bill really offers nothing to the lowlands, and what we'd all really like to see is some incentivisation for managing deer in lowland Scotland.
And in terms of lowlands, we're not really talking about south of the Central Belt, because lowland deer management, last time we took evidence, included Perth.
Yeah, that's right.
And Perth isn't south of the Central Belt. So
it's a good point. Highland boundary, fault and below, as a broad rule. But yeah, that's what we're talking about. We're talking about half of Scotland, is what you might describe as kind of a lowland deer management environment, and it's not really addressed by this bill in any way, shape or form.
Okay. We've got Alan, and then Peter, David and Duncan.
Yeah, well, deer densities and populations give you an indicative prediction of what the issues might be, but we do need to be guided by impacts, and the data, the ability to collect that data exists. So herbivore impact assessments, particularly strong methodology for woodlands. You could take that as a baseline. You could take that now in any part of the country, and you could assess what is the impact of browsing on this habitat. To what extent is it preventing that habitat or allowing that habitat to diversify and regenerate and adapt to change over time? So we do have that ability to collect that data, and we use that to guide. In fact, that's used by NatureScot and a lot of their site condition monitoring work. We use that to guide our own woodland restoration work, and it allows you actually you can quite quickly get an idea of what is the current pressure, and then you can track that over time. And NatureScot have developed with ourselves actually a kind of a light version of that we've trained stalkers to use. So they're really quite good guides in terms of what good looks like and what progress towards restoration is. So I'd contend we have a good handle on what restoration can be.
Peter.
Then going to your specific question about, Ms Harper, about different species in different localities, there's absolutely a huge variation in the damage that's then caused by that. So I think something so broad brush as this bill and the powers within it, which is trying to cater for all different settings, is potentially dangerous. So, right across Scotland is not one option. There are different localities and different things going on there. I think going back to Ross Young's point about lowland deer particularly, there's huge issues in peri-urban settings as well with deer densities and the damage caused there, and indeed what recreational stalkers contribute in that sense, and how their impact is measured within a lot of this bill, I think, is not taken into consideration as well. So it's a real complex issue, particularly in the lowland setting. So, yeah.
Thank you. David.
Thank you. A couple of bits on the sort of numbers question I think it'd be useful to come back on, and there's, consensus around the table that more information is definitely helpful, and the opportunity to gather that is helpful. I guess for me, there's two parts to this. There's the kind of strategic element, and we've had a bit of discussion already on, are we at 1 million, are we at less than 1 million? I think you can go back to 1959 when the Red Deer Commissioner are putting forwards the proposition that between 100 and 150k is already too high. So in some ways we could get very caught up on, are we at 1 million, not at 1 million? It's very clear that we're at a large number compared to where we've been historically, from that quote and plenty of others. So at a strategic level, that needs to guide what we're thinking about in terms of the national picture, and some of this bill stems from that in terms of that shift from damage to restoration, etc. I think when you then start to drill down into a local and a regional management context, you're thinking about your landholding, adjacent landholdings, etc. Then, switching that focus into outcome is potentially much more productive. So herbivore impact assessments actually on the ground, what is that population doing, and how is that impacting the land management objectives of the property that they are sat on, or properties that they are sat on. And I think from my perspective we could spend quite a lot of time getting hung up on a little bit of a cul-de-sac of a debate about, should we be nationally at 7 a square kilometre, should we be at 2? Actually it's that outcome and impact on the ground that really needs to guide the decision making within that context of clearly a very significant increase in population over a sustained period of time. And again, it's kind of immaterial whether that's 1 million, 1.2 million or 980,000. It's having an impact. I've demonstrated that already through 80% degraded peatland, 4% native woodland cover. So yeah, important to distinguish those two pieces of the argument, I think.
Okay, I've got Duncan, Graham and then Tom, and then I'm going to go to another supplementary.
Yeah, I was just going to say, I mean, we don't work in isolation here. I mean, many other similar countries to us have good systems of data management when it comes to managing wild animal populations like deer. Our systems are not at that level yet. As I said, there are systems which we, as Alan said, HIA systems which can measure impacts. I understand Nature Scott are also looking at the IAC system to get more information in on deer culling efforts, on farmland and lowland situations where we do accept that the data is deficient and needs to be improved. There is also the new deer app that Nature Scott are developing as well, which hopefully will improve the data flow. But we do need more people. I mean, it's a critical part of this bill and informing sustainable deer management that we do need to improve the openness and transparency of data management systems and the amount of data that we have in the systems. And we are not in that place at the moment, and it is really up to Nature Scott to do that. And there are things like the traceability system through the Deer app, for example, that could be looked at in terms of improving the data flow and getting more information into the system. But we maybe need a more mandatory approach to this.
Graham.
Thank you. So drawing a number of these points together, we're talking about different scales here, aren't we? We're talking about Scotland-wide and some broad sense of direction, but then, as people have said around the room, there's differences depending on the situation, the objectives around the country. So I think it goes back to where we started, really, that deer management plans are really critical, and the quality of those. We've used deer management plans in FLS for many years now, and have good data, set clear culls, and assess impacts and outcomes, and do that in a transparent way. So I think we've got, in Scotland just now, we've got examples of how this works, but getting that deployed on a much more widespread basis would make a significant difference, and having the legislation really supporting that, I think, is a real cornerstone to making progress.
Thank you. Tom.
Important just to mention, it's easy in a debate like this to get a little bit polarised. I think everyone wants to see improved habitats. It's not that we don't want to do that. All of the members of ADMG want to improve the land that they're managing or the land that they're working on. And a lot of people are doing the right thing already, and that needs to be recognised when good practice is taking place a little bit more, I think. I think what the deer sector need is reassurance on how these things are going to be taken forward, so that they feel part of the conversation.
Thank you. Mark Ruskell.
Yeah, I was interested in Grant's point about public institutions effectively doing a lot of the planning in this kind of area. So if the national park has a herbivore management strategy, I think Cairngorms might have one don't know if Loch Lomond Trossachs National Park has one yet. Maybe there'll be one for Galloway in the future as well. That's a plan that's in place. Within this bill, FLS will have to facilitate the delivery of that as part of the park plan. So you've got public institutions working to deliver that. Does that help to kind of guide and steer the public interest? And could that then be used, I guess, through the Code of Conduct, as a Code of Practice, rather, as a way for NatureScot to consider how private actors in that space are actually linking in with that objective? I'm just thinking about the status, particularly where you've got a park plan and a herbivore strategy. Does that have weight? Should that have weight? And how should that weight kind of be taken into account when NatureScot are making decisions to require those with private interests to take action that aligns with that public interest that's gone through a democratic process, being approved by a park board and everything else?
Yeah, I've got Rosalind Grant.
Thank you for the question, Mr. Ruskell. So I think by virtue of what's in the bill, national park plans and other plans that are kind of placed, if you like, on a statutory footing will be considered in the context of 6ZB. I think our concern with that is that, the bill is very broad, and I think one thing that would be really good for the committee to do is actually clarify, which particular strategies and plans, which particular targets are relevant to 6ZB, because that's not something we have got clarity on at this point in time. And I think it'd be really helpful for everyone to understand what those plans, what those strategies and what those targets are. But I think a concern from our perspective would be, where, for example, in certain plans and certain strategies, there's kind of an arbitrary figure of deer density that's required. How that would potentially interact with this power is a little bit concern for us. So I think we'd probably look for a little bit of reassurance there that, what NatureScot will be looking to do in this context of utilising this power is reasonable and proportionate. But I think there is grounds, just to answer your question directly, to take into account these sort of strategies, plans and targets in exercising that power based on what's in the bill.
Thank you. Grant.
Yeah, I mean, I think, within national parks, it's relatively straightforward in terms of you've got a statutory management plan that's approved by ministers that sets out the public interest, I think, in quite a lot of detail, really, in terms of what you're looking to do, and that involves looking at woodland, peatland, deer, whatever it might be, and all these different things. And then also we have to produce our nature network side of things as well by statute based on the other side of things. So I think in terms of that, setting that out, that's pretty clear in terms of a plan that then NatureScot, I suppose, in terms of looking at its powers, would then have to have regard to delivering. In terms of if the bill goes through, then it will have to help to implement that as well if the changes are made in the first part of the bill that we're looking at as well. So I think that's quite crucial. The bit that's interesting to me, and I think this is where the rub will lie on this, which is that the public interest articulated through a fully consulted plan might still not be entirely in line with what the private interest might be on that area of land, and you'll still have tension in certain places. So that's, you're not going to get away from that, and there'll be certain places where it will work voluntarily because actually that's what people want to do. There will be other places where people actually are saying, well, actually I own this land to do X, which is different to what the public interest would want to happen on that land, and that's where the tension will come, and that's where I suppose you will end up having those discussions which might end in voluntary agreements, or if it goes up the scale. So I think that's the tricky bit. But the point being, it is about if you have a plan that's publicly consulted on and is, it's not just saying. I think that's the question is what happens in other bits of Scotland which maybe don't have those same structures in place. What is the plan that you would use for, I don't know, northwest Scotland? But you take that as a sort of approach. So I think there's quite a lot in that. But that public-private bit, I think, is still the trickiest bit, which is where you get back to the powers eventually and what are you using your interventions for.
So on that basis, it could potentially become a very legal process. What plan trumps? Which plan comes out on top? Is it the National Park Plan, which this Natural Environment Bill might mean that you've got to abide by it? And what happens if you've got a landowner that wants to manage in terms of carbon credits or net biodiversity gain, or potentially as part of a community scheme to improve water quality or flood prevention? What plan trumps them all? Is it the National Park? Is it NatureScot being lobbied to bring in some control scheme? How does that work in the order of priority?
Yeah, well, I suppose the way that I would say the National Park Partnership Plan within the National Park flows from public policy in terms of other bits of Scottish biodiversity strategy, forestry strategy, whatever it might be in Scotland, which we try to take account of in terms of what does that mean regionally. And then it's from the bottom up as well in terms of going out and getting as much information from people as possible. So if there were estates that are wanting to do biodiversity net gain or natural capital or all these things, I can't think how that wouldn't fall in line with what's in the National Park Partnership Plan currently. In terms of, I think it's a statutory plan for there, it's a statutory management plan, so I think it would be given pretty high weight in terms of what we're looking to do in terms of the deer side of things. It's certainly something that we would expect Nature Scot to help us to implement as per the current have regard to in the Act, or a future help to implement power within the Act. So it's, that's something that I think is pretty clear. But I think that's how it would flow, if you like, between the national, the regional, and what's coming out from the bottom.
Okay, Duncan and then Tom.
Yeah, I mean, just say, I think I know in my own mind what the plans and projects that are being talked about here, but it would be useful to have some clarification around this. I mean, as ENGOs, we go out, most of us go out and consult on the management plans for our sites. And that informs the management plans for our own nature reserves or whatever. So, quite often we would like to be included in these kind of projects. I mean, we have a growing number of sites where we're doing sustainable deer management, both in the uplands and in the lowlands. And we would like to think that we can call on resources and support from Nature Scot where we have issues with achieving our land management objectives in those areas. And the other point I just want to make here is that, focusing on particular plan areas is one thing, but we do know that deer don't respect geographical boundaries, and even within a national park at that sort of scale, you will get deer incursions coming in from neighbouring ground. So recommendation 97 of the Deer Working Group report was for a cull approval scheme, which isn't on the face of the legislation. Actually, we need to reduce deer numbers across the whole landscape. So I would like some clarification also on how this cull approval scheme that is proposed will work. I mean, from what I've heard so far, Nature Scot are intending only to use it in very limited circumstances, when actually we think it needs to be applied much more widely. Nature Scot need to sign off cull levels to make sure we're driving down deer populations across the whole landscape to meet the whole variety of public interests that are affected.
Tom?
Yeah, just quickly on that point, deer management groups already set their cull targets 5 years in advance with Nature Scot, in agreement with Nature Scot, and if they aren't hit, then Nature Scot will come and tell us we need to shoot a few more, and that our plans will change accordingly. So there are cull targets already in place across the Highlands that are set with Nature Scot. Just on the plans, I think we need a little bit of clarity. I think we all have asked for clarity on that. The Scottish Biodiversity Strategy, for example, has a target of 2 deer per square kilometre in priority woodland. We're still unsure what priority woodland is at this point. And going forward, we've always worked with Nature Scot, and they are putting forward these priority areas based around plans. So I think there is a developing clarity around it, but it would just be good to be part of that discussion going forward.
Thank you. Just one final question in this section. Has anyone got any comments on Nature Scot's ability to cover expanded costs? Ross?
This is the recovery of expenses in the context of Section 8, so I think it's worth pointing out that the process is, I suppose, there have been some changes to the process, but it's largely unchanged from the 1996 Act, whereby you can object to ministers in the first instance, and thereafter you can appeal to the Scottish Land Court. One of the powers that the Scottish Land Court has is the ability to, I suppose, rule on the recovery of the expenses. One thing that we would like to see clarified on this point, Convener, is that they can vary expenses, but I suppose what we're looking to establish is whether they can also quash expenses as well. So the point of around varies there, but the point around quashing it in particular is not. But clearly, from a landowner's perspective, if they're subject to a Section 8, they're unable to undertake the deer management actions themselves for whatever reason, the cost implications of Nature Scot coming in and actually fulfilling that function could be very significant, offset slightly by the sales of venison, but as we know, that's something that we'll get onto that issue, I'm sure, in due course. But there is a procedure there. I think we just look for some clarity on that point around whether things can be quashed as well as varied.
Okay, David.
Thanks. Much to add to what Ross has said in terms of the specifics of cost recovery. I guess I'd just point out the opportunity we were discussing earlier in terms of Scottish Government having the potential to provide that overall cost incentive, at least for that initial cull over the next 4 to 5 years, potentially a saving compared to spend direct on cull through the relocation of the FGS money. So I'd loop back to that proposal. There's other options on the table here beyond cost recovery that could fill that gap.
Sorry, one point I neglected to point out. One thing that has been changed in respect of objections is that the notice, or the timescale for making objections has been shortened from 28 days to 14 days. No rationale for that set out in the explanatory notes or the policy memorandum, so it would be useful to understand from Nature Scott why that change has been made in respect of objections, or it might actually be more appropriate for Scottish ministers to answer that one potentially.
Okay, thank you for that. Just before we move on from this section on deer management plans, control agreements and control schemes, is there any further comments? Okay, we're going to move on to our... Sorry, do we have one? Did Tim... Oh, beg your pardon. Sorry.
Just belatedly give some gas to the Common Ground Forum and the way that it has pulled together the discussion about this. You've heard us all trying to drag the funding elephant into the room, and a lot of kind of consensus around that and how that can be shaped in practice. Tom and I are on the steering group for that. David's just joined it, and we've been talking recently about how we're trying to work ourselves out of business within the next 5 years, but we need the funding to bridge that. So if government is looking for a high-impact, relatively low-cost investment in transforming the deer sector, I think we'd all heartily recommend that.
Convener, one additional and very specific point in respect of Section 6A, 7 and 8 of the 1996 Act is that this bill removes the requirement in each of those sections for Nature Scott to have regard to the Code of Practice. Now, that is encapsulated earlier on under Section 5A. There's a broader kind of requirement for Nature Scott to have regard to the Code of Practice, but given the contentions that surround intervention, it might be useful for that requirement to probably comply with the Code of Practice in respect of control schemes, voluntary control agreements and deer management plans. That might be a useful change to make to those sections in particular, but restating that point and the importance of the Code of Practice and the importance of Nature Scott not only having regard to it but complying with it, I think is a really important point to put on the record.
Okay, thank you. We'll then move on to investigatory powers. Rhoda Grant.
Thank you. What are the views with regard to strengthened enforcement powers granted to Nature Scott under the bill, including the ability to enter into land if they have requested information and that's not been provided within 10 working days, and the proposed reduction in the notice period for that entry from 14 to 5 working days?
Peter?
So the reduced time frame in Section 21 and 22 will place significant administrative burden on landowners, and particularly those of multiple properties as well. A significant administrative burden will come out of that, and obviously the broad powers could at best be classed as intrusive. So these changes in this section are very concerning for our members indeed, and that shortening of the time frame in particular for the notice.
Thank you. Ross.
One point would be really helpful, Convener. I don't know if the committee would be open to this, but I think just again, it's not clear in the explanatory notes or the policy memorandum why that notice period has changed. If Nature Scott could provide us with the rationale for that, that would be really helpful.
Duncan.
I mean, I think we agree with what is proposed in terms of Nature Scott's new investigatory powers and the timelines. In some cases, you need swift action to get deer populations under control, causing damage or damaging the enhancement that you're seeking to achieve. So swift action is the order of the day there.
Okay. Graham.
Yeah, just to support that. We do that already. It's been pretty straightforward in that situation, and it goes back to my earlier point about having to take quick action sometimes. If you get an incursion, a serious issue, speed of response is very important. So I can see absolute logic of that reduced timescale.
Okay. Tom?
Yeah, just this is an emergency power, and it has been used quite a lot recently and quite successfully in various different places. It would be good to get clarity on why that time frame has been shortened, just for reassurance for our members. But just going back to this, the other regulations as well as this one, I think it's important to say that regulatory action has been used quite a lot over the Highlands. Our members haven't really objected to it at all. It's not that people are against regulation, it's just gaining clarity on when and how it's going to be used and the ground on which they're standing.
Okay, thank you. Move on to a question from Tim Eagle.
Yeah, we're just moving on to authorisations. So we had a wee discussion about that in the earlier section. So I think just comments around, I think it's 24 to 28, just around authorisations, the impact on deer management, the register, competence, one-off authorisations, and emergency uses of that authorisation. So just any comments on that would be very welcome.
Ross?
Thanks, Convener. So there's a number of offences that are created by virtue of the bill around it kind of being a criminal offence to take deer during the close season, criminal offence to take or kill deer at night. We're broadly supportive of this, and obviously the provision remains that you can get an individual authorisation or potentially a general authorisation in relation to the Register of Competence to undertake these activities. But we did have a question as to how this kind of quite blanket stipulation impacts in situations where you might have a necessity to kill a deer on welfare grounds. So if, for example, it was the closed season for a red hind and it was hit in a deer vehicle collision, and then there was a requirement clearly to dispatch that, technically it might be an offence, obviously, to kill that deer, but just kind of looking for clarity, I suppose, from ministers and Nature Scott as to how that interacts. In relation to the Register of Competence that was registered, I think broadly we are supportive of this. I think it does constitute deregulation in the context of wildlife management, which is rare, especially in this series of Parliament. We've had a lot of regulatory measures come forward, but ultimately our hope is that it will make things more flexible and it will reduce the requirement for landowners and land managers to require for individual authorisations if they're on this specific part of the register that allows them to undertake specified activities like night shooting and out-of-season culling. Then the idea is that they could operate under a general authorisation instead of an individual authorisation, and that is something we do support. It's flexible and that will help. The Register of Competence point was was mentioned in the previous section, and we do have a couple of concerns just around kind of accessing the basic register. So as a reminder, it's set into two parts: one for the specified activities, which is night shooting, out-of-season culling, and so on, and one for being fit and competent to shoot deer. I think the fitness point, that's going to be measured through having a firearms certificate, which is no problem, very logical. It's how competence is actually going to be measured, and it was really encouraging to hear the discussion between Robbie Donald and yourselves on this point. But I think we'd be looking for, obviously, DSC level 1 being kind of the standard, but also some room for flexibility in situations where you have a professional deer manager who's been at it for 40 years, that's not done a deer stalking certificate level 1, but could easily provide you with a referee or a reference that supports your ability, I suppose, to kill deer professionally. So I think just a couple of points around that. And then the final issue with the Register of Competence, and again this was mentioned, just that point around ensuring that those that are coming to Scotland to shoot deer as a guest, as a sporting guest, are exempt from that Register of Competence, providing they're accompanied by someone that is on that register. And really we'll be looking at, as long as you're within earshot or eyeshot of that person, that being kind of the basis on which that proceeds. But broadly on this section, relatively supportive, bar just a couple of the questions that I've raised there.
Just before we bring Peter out, so does that need, when it comes to a visitor, does that need to be specified on the face of the bill that accompanied is defined?
So it's not in the bill at the moment, to my knowledge. I can correct the record if I've missed that, but I think it is important that I think we do need to be clear about what accompanied actually means, because our view is that earshot, that would generally be what is used, which gives you slight capacity to kind of operate a little bit away from the trained person if circumstances require. Because the other point to note in this is that when people get into stalking in the first instance, there is a requirement to do some kind of autonomous stalking on your own, and actually as long as you're within earshot of someone that is on the register, I would have thought that would be perfectly reasonable and proportionate, but I think getting some clarity on what accompanied means in practice would be really helpful.
Okay, thank you. Peter and then Tom.
Yes, BASC have serious concerns actually around defining what this competence level would be within the bill. Self-regulation has served us very well over many decades and ensured that we've had high standards, and that's obviously on a voluntary basis. BASC offers training courses like DSC1, DSC2, however that is on a voluntary principle, and making this now mandatory does pose significant challenges for the sector, none least a barrier to entry, and indeed at a time when we see the average age of a deer stalker being 58, this is quite concerning for future deer management and how we cope with that. We haven't seen any empirical evidence to that effect that points towards introducing mandatory training or a level of competence that would be mandatory. So therefore, you know, we'd ask the government to provide that for us. We have not seen that to date, because at the moment these will produce significant barriers indeed for future deer management and how we go about that, and in the context of this bill. And certainly, if we're looking at people who currently manage deer, there is no concession, for example, grandfather rights, or indeed any financial incentivisation to conduct further training if it were mandatory. So serious concerns from our perspective.
Okay, thank you. Tom.
Thank you. I think as an organisation we're broadly supportive of many of these proposals. What I would suggest is that wherever there are changes put in place, then best practice guidance is changed appropriately as well. For example, where night shooting's changed, where the use of thermals, etc., is used, you know, that best practice guidance should be appropriate for the standards required to shoot deer. I also think that authorisations should have a reference to land holdings. Going back to that value of data, I think all authorisations should be recording where things are shot, because otherwise we're going to have even less data than we currently have.
Okay, I've got Alan and then David.
This point about deregulation, and Tom's going to make the point about the need to secure data, what gets shot, where and when it's shot each time.
Yeah, I would support previous points as well. A couple of things to add just on the RTC and out of season. I think Section 25 of the 96 Act would probably cover you, but with, as you say, getting some further clarity on that. A couple of welfare issues I'd pick out in this section of the bill that are probably worth touching on as well. So ending use of shotguns to kill deer unless under authorisation. I'd also particularly pick out ending use of lead ammunition, which might foreshadow some of our conversation on venison and the venison market as well.
Okay, I'm going to bring in Edward for a comment here.
Particular point quickly, is that okay?
Yeah, I think this is on this particular point as well, Edward, isn't it?
Sorry, it's just a point of clarification, if I may. The committee may be minded to consider the fact that if this is going to become a requirement to be able to shoot deer, that Police Scotland may interpret this as a requirement to own a rifle capable of shooting deer. And I think that that's actually a step that might go too far, because you don't need a qualification to shoot foxes, for example. So the rifles may become limited, and I just think the committee ought to ask the police what their views on the interpretation of that is. Sorry, it's just a point of clarification.
No, thank you.
I will shut up again.
Thank you. Graham, and then Duncan.
So, again, we can share some of our experience on particular authorisations and competence. So, start with competence. For all of our staff and a significant number of contractors, we require they all have DSC 1 and 2. And in the last year, we've got several contractors have taken on trainees, which is really encouraging. That point about the ageing demographics, so we are getting people coming through, which is encouraging. And we also have a number of apprentices as direct staff, so that is happening. But there's interest there to join and make it a career, which I think is good for people to hear. I think the public confidence aspect mentioned by Nature Scott is really important. So, both safety and welfare. I think having some clarity around how competence is defined is really important to keep that public confidence. In terms of authorisations, we've used extensively night shooting, particularly in out of season, for a number of years, following best practice, and they have been key to deliver the sort of culture we've been achieving. Without those, using those authorisations, we would be well short of what we've been doing. So, our experience is they are really, really important to achieve the ambitions that we're all trying to achieve.
Duncan.
Yeah, I want to take a slightly different slant on this. So, we support the overall principle of having accredited hunters. I just wanted to draw on, I know we're coming to venison later, but when it comes to venison, Norway have a very good system there where accredited hunters can supply venison into local markets. This isn't national to supermarkets and that kind of thing. It's to friends and families, local restaurants and that kind of thing. I'd like to see some consideration given that if you're an accredited hunter, you've been through the food hygiene and all the other parts of the accredited hunter package, that actually you can do that, because I think it's in everybody's interest. If we are going to be increasing the deer cull as is proposed, then we need to have good places for that venison to go to. So we need to encourage locals.
We'll be moving on to that to cover it more fully. Yes.
Convener, that somewhere in there, I mean, looking at the sort of hunter-trader system they have in Norway would be a good idea.
Okay, we now move on to our next theme, prevention or stopping damage by deer. A question from Beatrice Wishart.
Thanks, Convener. Section 20 of the bill introduces a new defence for actions taken to prevent or stop a deer from causing harm to a person. In your experience, is this an issue that needs resolving in legislation?
I've never come across it.
Yeah, likewise.
No. Alan? No. A rounded no. We're all in agreement, which is very unusual around this table, particularly with so many stakeholders. So no other comments about Beatrice's line of questioning? No. Nice and easy. We may have the same response. And our next question from Elena.
I think this might be short and sweet as well. So, Section 32 of the bill introduces an offence of failing to report the taking or killing of a stray farm deer. So my question is to stakeholders, are stray farm deer a problem in Scotland, and do you agree with the provisions as set out in Section 32? Oh,
Tom.
Answer.
I don't think it's that common, no. But most farm deer, and Dick Playfair will probably be able to put us right on this, most farm deer have an ear tag anyway, so they're quite identifiable.
I was going to make that exact point. There's around 80 deer farms in Scotland, most of which use ear tags for identification. These animals are not wild. I think broadly support. I think it's quite similar to FLS's policy on stray sheep. Yeah, pretty much a like-for-like lift. So, yeah, support.
As expected, short, succinct. We'll now move on to our final theme around the licensing of venison, dealing in venison. I'm quite sure Dick will be very happy because he's been very patient. We'll get a question from Emma Roddick.
Yes, thank you, Convener. I did want to ask, obviously the bill reduces a lot of the bureaucracy around venison, and I wondered, do you agree with the venison dealer's licence being repealed?
Our actual situation, and I think this was in our response to the consultation, and some others at this meeting will have supported that too, is that actually we don't think the venison dealer's licence should be removed at this point until there's something to replace it. Scottish Venison went through an interesting discussion with Food Standards Scotland back in February 2024, really to talk about this and see what their view was. Now, interestingly, I don't think they actually responded to the Deer Management Climate and Nature consultation. But their view as well was that until we've got sufficient safeguards in place for the sector, we shouldn't be thinking of removing the ones that we have. Now, I know that at the round table session, it was suggested, and it's backed up in the financial numbers that have been supplied, that there are only something like 26 new applications for venison dealer licences a year. If one considers that the only route to market for venison, unless you're selling through an AGAG, is that someone in that supply chain should hold the venison dealer licence. It actually shows that the system isn't working, but it doesn't say that a system shouldn't be there. And from a food safety, from a food legality perspective, we think that there does need to be some element in there which is going to ensure that that's the case. Public confidence is all important in the venison trade. And we can't just say, because this isn't working, we need to get rid of it. It's not working because it hasn't operated as it should operate. Supplementary to that, I guess, is that one's relying on 30 local authorities separately to run the system. And the question is, I guess, would it run more effectively with one authority taking on that responsibility? So you do have this disparity in terms of cost. You do have this disparity in terms of when somebody should actually apply. Who should apply? Should that be the retailer? Should that be the producer? The system is a muddle, but that's not to say that we can't actually implement a better one. And crucial to that too is that if we can collect data from such a system, we can use that data. And at the moment, data is precious, scarce, and we're really not using what we are collecting as we should when it comes to venison.
You put quite a few questions there. Do you have answers to them around what it should look like, or is there another system that you think could be borrowed from for venison?
I think the two areas really are, one, that the system could be standardised and every local authority could take on a standard system where the costs were equivalent across them. So depending on where you were, you wouldn't be paying in one local authority area £300 or 120 somewhere else. The alternative is to develop a system that is not clunky, that is modern, that is data-driven, and that really, Nature Scott are working on this as it stands. There should be something there that will allow a carcass to be recorded and traced from the point of shot right through to that pack being on the shelf for sale. And again, I would reiterate the point that if you're going to take away an element that allows you to do that now, you are in fact taking away confidence in the system.
You did mention kind of public confidence twice there, and I wonder, do you think that's still quite a big issue with venison or game in general when it comes to the public purchasing for consumption?
It's a question of confidence. It's also a question of education. On the confidence side, we can't disregard the fact that we had a food scare in 2015 in the venison sector. We need to learn and have learned lessons from that, I think, in that certainly across a number of areas, people have woken up to how important venison is to the whole deer management sector, and that really people have to remember in this whole deer management discussion that they're in the food business. That's ultimately one of the important aspects of what we are here to supply. So, yeah, we need confidence, we need education, but what we don't need is undermining that confidence.
So just final question then, do you think that in the progress of this bill there's enough time to design a whole new system, or does this kind of need to be paused and looked at another time?
I think there can be a provision made in the bill which actually is not one that says we abolish the venison dealer's licence, but one that says we reserve the right, whatever, to abolish that licence when there is a replacement system that can be put in place. If I might, Convener, I'd also like to add that I think the crux of a lot of the discussion today and what can drive everything in the right direction is incentivising the deer sector, but specifically incentivising the venison sector. And I think, with all respect to the schemes, the three schemes that are in place at the moment, the three pilot schemes, they are geared to a headage system. They're effectively geared to the fact of shooting more deer and getting a payment for it. We actually think that it would be much more productive if such a system was moved so that it was geared to the venison that was going into the food chain and not to the carcasses that were hitting the ground.
So does it appear that the government have taken the position that they just want to control as many deer as quickly as possible, and having any sort of a pinch point, which may be the ability for venison to reach the food chain, and we should just remove the regulation there to make that easier without actually looking at the consequences of the public confidence?
I don't think removing the regulation will make it easier. I think currently there must be a lot of abuse of that regulation going on anyway. and it's simply not being enforced as it should be. I don't think the price element of it or the cost is a factor. You know, if it's £80, if it's £150, really that's not an impediment to somebody wanting to put venison into the food chain. And with respect to the government, I think there is an awful lot of activity and discussion around the fact that we need to, we have this fantastic resource which we need to open up. And there's a lot of good work going on in terms of local processing, in terms of consideration of concepts, as Peter has mentioned, around community involvement. Certainly it would be a solution for the low ground where you don't have deer management groups to actually have community chills or larders that could become the focal point for that activity. So rather than starting at the multiple land ownership end and trying to get everyone to agree on what they were planning to do or not, you actually say, well, here's your route to market. Now let's start at that point and work back from there.
Okay, thanks. I've got Ross, Tom, and then Grant.
I was going to support pretty much everything that Dick has said there. The VDL isn't perfect. You know, in a lowland context, we see a lot of people, partly due to the unavailability of larder and chiller infrastructure, processing a lot of venison they shoot by themselves, and they're kind of limited almost in some cases by the amount that they can actually get in their freezer. That's the prohibiting factor, impacting them doing more deer management. So I think the VDL does have value. It's not perfect, as Dick says, but really, before any changes are made to it, there needs to be provision in place to replace that data. And there's really interesting work going on at the moment. NatureScot have done a power of work in conjunction with FLS, I think, on developing the a national deer app. Now that's it's looking really good. Like, it's getting close to kind of its finalisation stages, and I think it does beg the question: does that app have a role in the context of this bill? And could actually this be an opportunity to really kind of get that out there and actually start utilising it? Because it would manifestly change if everyone started using that app. The data collection point would be vastly improved, and if we can get it so it goes from the person that's actually culled the deer on the ground all the way through to where it actually ends up putting venison on the shelf, I mean, I think that could be genuinely transformational. So my suggestion in this section to ministers is not to go too fast. I think give themselves maybe enabling powers to make changes by regulation in the future. That would probably be the sensible thing to do. But I think for the time being, until we've got that kind of alternative in place, I think it would probably be short-sighted to get rid of the VDL now.
Okay, Tom.
I also support everything that Dick has said. It wasn't that long ago, I think it was 2015, when Food Standards Scotland stood up at our AGM after an E. coli outbreak in venison and said, if it happens again, we're shutting the industry down tomorrow. Now, that's a disaster as far as most deer managers are concerned. That's, for many, the only income that's coming in for them. I think we need to promote quality assurance going forward. There are schemes that are in place. I think we need to normalise venison and make sure that it's going into our schools and hospitals. I think public procurement is vital. I think we need to be encouraging people to eat venison once a week, and I think that's something that the whole sector can get on board with.
Grant, Peter, and then I've got a supplementary from Mark.
Yeah, I mean, not to comment directly on the venison deal licensing side of things, but in terms of the deer app, the Strategic Deer Board had a meeting on Monday, and the app was one of the things that we discussed at that, around the traceability side of things as well. And I think, you know, there's some really, it looks like it's really good, and I think there is something there about how we can think about that. There is also a resource implication for NatureScot and others in terms of rolling that out. It's quite a big thing to do in terms of across all of that, so there's considerations there, but I think there's a really good bit there going forward. And I just think there is, I think, an increasing amount of support on the larder side as well. I mean, the Park Authority itself has recently funded 2 larders. I think we've got applications for 4 more, and that's really looking at the community side of things, and also linking back into increasing culls in certain places. I'm not as convinced on the price side of things in terms of supporting that on the venison side, rather than some of the stuff we're doing through the pilots. I realise there's pros and cons of each. I think there's just a case of trying to see what the best thing is in the right places. But I think overall there is something about trying to make sure we've got the right capacity in the right places. And the traceability, I think, is the key thing around that. And if the app can do some of that, then let's see what we can do.
Yeah, okay. Peter, and then Duncan.
So yeah, I think one of the main outcomes of this bill should be more venison on the plate. I think that is absolutely echoing a lot of what Dick Playfair said on that. I think there's a community aspect and there's an education aspect to that. I did allude earlier to community integrated deer management and helping communities access that venison through recreational stalking on publicly owned land, and then the larger infrastructure that subsequently follows that to ensure that communities can tap into this resource. I suppose I'll just finish on a positive note. BAS goes into schools and does educational days such as Hill to Grill days, and I can certainly say that the young generation, the new generation coming through, there is a real appetite for venison, and through those days and through the curriculum we can see that being developed. So I hope it does have a positive future and that is a positive outcome of this piece of legislation.
Thank you. Duncan.
Yeah, I'm not going to disagree with what Dick said because he knows more about this than I do. But before I came here, I did have a conversation with Cairngorms Connect Venison, who are a small producer, just to sound them out on their views on this. And they said at the moment they're working to 3 systems. They've got the venison dealer's licence issued by Highland Council. Then you've got Scottish Quality Wild Venison Dick's scheme there, and then you've got Food Standards Scotland. So this does need to be rationalised. At the moment, from what they're saying, the venison dealer's licence is applied, quite randomly, depending on which local authority you're in. It's very patchy the way it's applied. So I agree with the idea of having something, until the venison dealer's licence is replaced. But I think it does need to be reviewed, and we need to move to a system that is easier for small providers, because at the moment that's quite burdensome the way it's with 3 agencies or 3 groups effectively involved.
Thanks. I've got members got supplementaries. Rhoda Grant was actually first indicate. Rhoda, and then Mark and Emma.
Thanks. I just wonder if there is a way of kind of fitting this in with the current meat hygiene system and using abattoirs and the like. Something we really need in rural areas, especially, is micro abattoirs, and I wonder if there is a way of using venison to go in with other local produce that actually makes that more sustainable and creates more of them. Would that be a possible solution?
That has been looked at, Rhoda. It's not really a solution per se, in that one is better with micro-processing specifically for deer, in terms of efficiency, in terms of lairage. So no, I mean, it's that, and mobile chills have also been another solution that's been proposed. But actually the pilot schemes that we have running currently, and with another 16 or so projects that have been government funded or will be government funded in the pipeline, I think will develop quite a lot of data and quite a lot of evidence in terms of what works. It's really, at the volume end of the spectrum, we obviously have approved game handling establishments, Food Standards Scotland as the regulatory authority, and a supply straight into them in terms of volume. The nut we need to crack is getting that product, which is often, the carcasses are far smaller. We're talking roe deer here. We're often talking 12 kilos as opposed to 35, 40. So the return to the producer is that much less. And if we can develop a system that will work for them, then that really is going to take us towards achieving quite a lot of the solution that we need.
Thank you. Mark.
Yeah, I suppose I'm just struggling to understand how venison dealer licences really kind of address that risk that the FSA kind of articulated around E. coli, because if the meat already has to meet Food Standards Agency requirements, and if that was a warning the FSA gave in 2015 at a time when it all has to go through those who've got venison dealer licenses, I'm not sure where that kind of risk is. I mean, it feels like we're discussing more around traceability and how you communicate to the market and deliver that through apps and security and quality assurance programs rather than something which I don't know. Maybe I'm just not fully getting it.
No, I think that's right. I would like rather than just throw venison dealers' licences away, I'd rather learn from the mistakes, create something that does work and move on, right. Rather than ditch it and then nothing happen,
Yeah, thanks. Yeah, just for clarification there, because in Scotland and the derogation that we have for small quantities to be sold locally, it is possible for small producers to be able to put product directly into the market and not for that product to go through an approved game handling establishment. So FSS are the responsible authority for the AGHEs, which are the likes of Highland Game and Ardguy Game and the major processors. There are some smaller ones emerging also. But it is possible for your local producer to be able to supply his local market through his own processing or chill. And the only, if you like, under current legislation and under the current Wild Game Guide from Food Standards Scotland, the only exception to not holding a venison dealer's licence is if you're either gifting your product to family or friends or if you're supplying an AGHE. In all other circumstances, you have to involve the local authority. And it has to be sensible that there must be some type of overseeing of that process for that food to be safe, to be traceable, and basically to be in a system where it can be accounted for in the event of a food scare. Okay.
Okay. I wonder if, this goes back to the point I was mentioning earlier about the Norwegian system where you have accredited hunters who've effectively on a sort of, there they have hunters training hunters and a very robust system there, trust within the system that people have to conform, otherwise it affects everybody in the industry. Whether we could look at that and see whether there are some lessons to be learned that could be applied in Scotland.
Any other comments? No. Emma.
So it's just a quick thought about Quality Meat Scotland being part of the engagement and support of venison as red meat, because they already have confidence in beef and lamb and selected pork. So does more work need to be done with the likes of Quality Meat Scotland to basically convey confidence and integrity in venison food supply chain?
Many years ago, probably 15, I would think, we had discussions with QMS in terms of venison and the red meat sector and whether QMS might be able to take venison under its wing. And the conclusion of those conversations was that it would actually cost QMS as much, or the only thing they could do with the levy that they collected from the venison sector was pay for the collection of that levy. But they wouldn't be able to give venison the same promotional clout that currently is being given to beef, lamb, pork, whatever. And clearly there are subscribers into QMS paying that levy. The last thing they, if I can say this in this room, the last thing they would want to see would be another red meat being introduced that would diminish the volume sales of their lamb or beef. So, we have to admit there's competition in the sector, and we see venison very much as being, if you like, the smaller components, the smallest component, the little brother who's having to punch very, very hard. But yeah, there maybe could be conversations still to be had, but in volume terms and in terms of funding that might accrue to the venison sector through QMS, it would be very, very small, I think.
Okay.
And would also, if I'm correct in saying this, would probably also demand legislation and changes to how QMS operates at the moment to bring venison into the QMS stable.
Okay, thanks.
Okay.
It was touched on earlier, but the public procurement side could also be very helpful here. Hospitals, schools, prisons, in terms of supplying venison. I think it would be very helpful as part of this process to look at that, as well as looking at the QMS type, because marketing and promotion is pretty critical in all of this. as well.
Sadly, this committee who dealt with Good Food Nation.
Regular supply in terms of public procurement, that would also provide some underpinning for the sector.
It may form part of the Good Food Nation plans, but unfortunately, given the capacity of the Parliament to deal with these secondary legislation, we're actually not able to deal with it, which is unfortunate. I've got Alan and then Dick again, please.
I was just going to note the progress made by Scottish Quality Wild Venison to provide that kind of confidence to market and provide that full traceability that Dick was talking about earlier. I think there's been real progress on that recently. It's been very welcome.
Thank you. Public sector procurement is one of the major strategic aims in the venison strategy, something we're really working hard to take forward. There is actually a public sector procurement group which has been set up by the Scottish Government, which involves a number of separate strands of those operating in the sector. And we met for the second time yesterday. It's tremendously encouraging to hear what is happening in terms of public sector and their buy-in to venison. I mean, the Hill to Grill projects have been mentioned already, which are a crucial educational aspect, not just because they can result in venison going into school canteens and dining rooms, but also that they're taking children out on the hill and allowing them to see the whole process from start to finish. But in addition to that, people will probably have seen Wild Jura and their success in securing a contract with Argyll and Bute Council to supply into schools. And they have just won a national public procurement award. Really, again, evidence for the sector that you don't have to be big to make this happen, and that it is possible for producers, local producers, and a small processor to be supplying into the public sector. Highland Game are well down this route now in terms of education, in terms of NHS trusts, where they're supplying into certain hospital trusts in England. So, I mean, that is actually moving forward, and conversations which we're having with the wholesale sector are also really, we're getting encouraging feedback that venison has a lot of the right attributes that make it very attractive towards public sector procurement.
Thank you. David.
Thanks. I was going to highlight one of the same case studies that Dick has just brought forward in terms of Argyll and Bute, so I won't repeat that. I guess also perhaps worth looping back to the kind of broader case for Scottish Government providing some of the financial incentive. If you've got the government incentivising the cull, then I think that adds to the case for public procurement, also utilising the output of some of that cull. So worth bearing in mind that nose-to-tail element of the process.
Yep. Elena.
Yeah, I'm just interested in understanding the group that's been set up to look at the public procurement in terms of venison. Exactly how is that operating in terms of looking at how local authorities write their tendering contract? Having previously been a councillor in East Ayrshire, where we have a huge amount of public procurement in terms of school meals coming from local producers, it was actually transforming the way that those tenders were written and the way that the person reading the tenders actually interpreted the information they were given. So is that going to play a role in this? Because it's not just about driving the costs down. When you're tendering for those things, it's actually about looking at the wider picture.
Yes, I think it will. I mean, I think what we haven't done to this point is actually make local authorities aware that venison is a healthy food choice that is available to them. So, I mean, conversations with the likes of Scotland Excel, for example, which are now taking place, are going to start opening those doors. And certainly with the wholesale sector, where you have the likes of Brakes and Bidfood, who are already supplying into the public sector, I mean, that will certainly help. I think one of the issues we're up against is that a lot of these menus, if you like, menu choices, are decided a very long time in advance and obviously determined by price too. So for those supplying venison, clearly, it can't afford to be discounted to such an extent that the supply is more important than the actual return. but equally, we can't overlook the fact that we've got a really good story to tell. We have potentially the best story to tell of all red meats in terms of sustainability, in terms of everything we're talking about regarding the environment, in terms of biodiversity gain, in terms of the product itself. It's an exceptionally healthy red meat. So, if we can't make this work now, and if we can't make this work in the next 5 years, we're doing something very wrong.
Okay, thanks. Edward Millington.
Thanks, Convener. It appears Section 20 of your bill seems to be fairly uncontroversially agreed by everyone. Section 20 of the Land Reform Bill, which is in the committee that I'm part of, it talks about game damage and the tenant having a right to, has no right to kill game to be able to seek compensation from the landlord. And that includes damage to crops, trees, fixed equipment, livestock and habitats. And for the avoidance of doubt, game includes grouse, so capercaillie, if they ever come back, are included in there. Black game, of course, pheasants and partridges, and of course deer. Now, if a landlord was pursued by a tenant for game damage on the tenant's land, would the landlord's defence not be, well, if the deer management group controlled the deer because I can't control red deer across the whole range, there wouldn't be a problem, and therefore does the group feel that it might leave them, if they're part of a deer management group, exposed to claims from tenants who would be trying to seek damage from the landlord, who would then chase the deer management group? It's just an idea which I think is worth considering.
Anyone like to comment? Ross?
So, Convener, I think it's a really good point that Mr. Mountain has raised. The reality is that deer are obviously really transient. They go across a very broad range in some cases. Pinning particular liabilities on a landlord where a tenant has suffered damage may not be within the gift of said landlord to actually adequately control those deer if they've been on that ground for a relatively short period of time. The reality is that it could be as a consequence of a neighbour's actions or lack thereof that are causing the problem. So I think it does introduce a real problem, and I think it's probably something that needs to be looked at in detail because deer are transient and they can come from a very broad range. And I don't feel like that's probably been looked at in the context of the bill so far.
Tom? I think it does certainly need to be considered. We all manage deer on a landscape scale in the Highlands for exactly that reason. Deer move around, and the ability for people to have a sensible discussion around deer management issues like that needs to be facilitated.
Peter?
I was just going to say briefly, I know the Land Reform Bill is going through the NZEC committee, but we've been looking at particularly both this bill and Land Reform Bill, and it's unclear at the moment how the two will interact with each other if passed in the current form. So that's something which we'll be seeking clarity on in particular, but I know that's out the remit of this committee.
One further question, Convener, if I may, is, I know everyone's different. I'm quite happy to be a refuge for wildlife that are being persecuted round about me. Not everyone is in that case. But one thing that's clear is the ministers are going to have powers under the Land Reform Bill, if it's passed, for zoning of estates that are over 1,000 hectares that are put on the market. Now, that zoning can be into small packages of lotting, and sold on. And my question is, given all that the bill is trying to achieve with deer management, which it appears to be done over a bigger area because they wander more, is it going to affect what this bill is trying to achieve if some of these estates, especially across some of the more remote areas, or even forestry and land Scotland, if you segment it all up and sell it all off, is it going to affect what you're trying to achieve in this? Might be a good idea, that, but is it going to affect what this committee is trying to achieve with the Natural Environment Bill? That's my question.
Tom?
I think where landholding sizes are reduced, potentially through the Land Reform Bill, I think that could become a significant challenge for the deer management groups that we represent. You know, it's clear that in a lot of those deer management groups where there are more land holdings, it becomes more complicated. Collaboration is not a straightforward thing. At the best of times, with more people involved, it becomes difficult. And the transient nature of deer and the fact that they move around over large land holdings, over large areas and a number of land holdings makes it very difficult when they become more. I think there's no surprise to me that, you know, the challenges in the lowlands, where there are smaller, more fractured land holdings, you know, that's where the collaboration is more difficult. And we don't want to create that going forward, in my opinion.
Okay. Ross. Oh, David.
Yes, going to make a similar point. Thank you. So across the 24,458 hectares that we manage across Scotland, then it's that collaboration and partnership approach that's first. And some of those are very small partners, some of those are big partners. What you're looking to do is stitch together that coalition of interest across the scale that you need to act. And the powers in this bill should be a backstop for where that collaboration hasn't achieve the aims that it needs to achieve, or there isn't that consensus between the landowners who are operating at that scale.
Thank you. Small.
Just on that similar vein, because I've also on the NZEC committee with Edward Mountain, I was interested in how you think the provision of land management plans that's in the Land Reform Bill will help or hinder. Clearly, it requires some community engagement. Do you expect it to cover deer management? How does that change the dynamic in terms of getting a local consensus with surrounding communities and landowners about what appropriate objectives are for deer management? Or do you see it as well, something that landowners just might not consider as part of their land management plans?
Tom? There are deer management plans that cover 3 million hectares of the Highlands already in place. Some of them need updating, but they all refer to woodland creation, peatland restoration, deer numbers, agriculture, what's happening on the land. They have a 5-year plan going forward, and they have working action plans now. They do need to be updated, and I think that this process has probably slowed that somewhat because people are thinking, well, what's coming next? What do we need to put in our next deer management plan? But I think that the proposal for land management plans will just duplicate much of what is already there and is in the public domain.
Okay. Ross and then Grant.
The other inherent challenge, of course, of land management plans is it will only apply to land holdings above a certain size, and I know that's a topic of live discussion at the moment. The implication of that is where you have properties that are less than that threshold in a particular deer management group is that they potentially won't be including deer management as part of those land management plans. I agree with Tom. I think it does risk duplication, and given that there's a specific section of the 1996 Act, which is Section 6A, that deals with deer management plans, they are defined kind of legally as something distinct from the land management plans, and I would probably anticipate that continuing to be the case going forward. But I think it's important, I suppose, for MSPs and ministers to recognise that in producing a land management plan, there are deer management plans that go alongside that. How that then interacts with a land management plan, I think, is a question that probably does need to be looked at.
Grant?
Yeah, I suppose my thing around this is that we do produce a lot of silo plans, which are deer or forestry or peatland or name your plan, there's a plan. I suppose what I would hope, and this will take some time, is that if the land management plans were introduced and we thought about it carefully, could we actually reduce the number of plans that people have to produce, but in a more integrated manner so that people can see how all these things actually interrelate to each other? So I think there's something about thinking about the land management plan side through the Land Reform Bill, but also then thinking over time, and it will be time because there's no way you can do this all at once, of actually then saying how can you reduce the number of plans required and make it easier for people to understand what estates do, because you have to go to a hell of a lot of different sources to try and find out all the information about one place. And that seems to me to be something that we really need to think about. And on the lotting point, all I'd say is I don't think there's an answer to that, because I think it depends. It depends on who bought the land. It depends on whether they'd want to get involved. You could have 5. You could go from one person who's being obstructive to 5 people who are not obstructive, and vice versa. You go from one person who's to the other way around. So I just think that depends on who eventually gets land, if lotting ever happens.
Oh. Reduction in plans, that's a novel plan, isn't it? I know. Will it ever catch on? I've got Duncan and then a supplementary from Edward.
I just agree with Grant and just make the point that clearly not all land holdings, even in the Highlands, are in deer management groups. I mean, for example, there are quite big areas of the Loch Lomond and Trossachs National Park that aren't in deer groups. And, I mean, from our perspective and in the interests of trying to get more deer management happening across the landscape, I think it is important, whatever comes out of this, that deer management is at least a theme of the sustainable deer management is a theme of the land management plans that are proposed to be introduced.
Graham and then Edward.
So we've been through some of this. Used to have lots and lots of different plans. So we've reduced that. So used to have what we called forest design plans, being forestry body. And the last number of years we've now called them land management plans, recognise we manage multiple objectives. It's not just forest. Deer is an important component, and what we've learnt is really helpful is then it gets a bit clearer link of why you're doing the deer management, how you're going to do it, and what the outcomes and objectives are, rather than being on its own. So I think, again, we've sort of tested that approach, and as I said, I would very much support moving more in that direction.
Okay, thank you. Edward.
It's just to say one brief thing. Having done 3 deer management plans, albeit 20 years ago, I accept they are a huge amount of work because of the amount of people that you're involved, and costs varied. And without going into specifics, I think the cheapest one was 25,000 and the most expensive was 50,000. So be careful what everyone wishes for when it comes to getting deer management plans, because they are massive and complex with multitude of ownership, and within that ownership, different times of year for deer management. Very complicated.
Thank you. I'm glad you put on record your register of interest at the start of the meeting, Mr. Minton. Thank you. Just a very couple of very quick questions. We talked about incentivisation. Should sporting rates play a role in this? We have sporting rates, a very traditional tax. Is that a route where incentivisation could occur by reducing sporting rates if certain objectives are met, or is that something that we should consider as part of our work? Ross?
It's worth saying, I think we're kind of formulating our position on this at this point in time. This bill does feel like a potential opportunity to look at that if that was required. I think the point I'd say is that this situation is hugely variable in respect to sporting rates. A lot of businesses are exempt from them for various reasons. I think the actual implications, we'd need to do a little bit of kind of surveying of our membership and kind of come back to you with a more explicit answer on that. But it's certainly something we're taking an interest in and looking at.
Okay, thank you. And Tom?
Worth considering for sure. I mean, I'm not sure they're working entirely appropriately anyway. I think it'd be worth revising them and removing them. You know, it's just another burden on deer managers that probably isn't really required or generating any income anyway.
Okay, and just from my point of view, a clarification around the venison dealer removal of that requirement. Is there a consensus that we should be looking at a replacement or something that will safeguard some of the concerns or address some of the concerns you've got, and a commencement date to remove a venison dealer licence at some point in the future? And should that form part of the bill?
I'm not sure it necessarily needs to form part of the bill, but I think as it appears in the bill at this moment, certainly the abolition of the venison dealer licence with nothing to replace it is a risk to the venison sector.
Okay.
Convener, it's probably better if it said something to the effect of Scottish ministers may abolish under regulation sometime in the future. That would probably at least give time to get something appropriate in place.
Okay, we are almost bang on time. We've got 2 minutes if anybody has got any comments. But Alan?
Incentives. Convener, in looking at options, I think it's worth considering how to best directly support deer management jobs for the long term. And I think it's part of that calculation, which, if you're thinking through sporting rates, it's going to be relevant.
Okay, thank you. Duncan?
At the risk of opening up a whole new debate, we haven't touched on female deer seasons. Nature Scott came up with some quite sensible proposals around female deer seasons, which I think do need some greater scrutiny by this committee. I'm not saying, but if we are going to manage deer populations and reduce them over time, the hind and female deer population is pretty important in that context. So I think looking again at what Nature Scott proposed, I mean, we, the Linked Deer Group, support an evidence-based approach to female deer seasons, whether that be on animal welfare or other grounds.
Okay. Ross?
On this specific point, Convener, I mean, the provision remains that you can get an individual authorisation to undertake out-of-season culling. There's potentially opportunity within the new register for specified activities to potentially make that more flexible as well. I do just think that the issue around culling deer out of season is a really contentious one, and those that are on the coalface of it have got some really strong and very valid views. I think ministers have made clear their intention that they're not planning to do anything with it. That doesn't mean, of course, amendments won't come forward to that effect, but I think we do need to put the people that are ultimately being asked to do some fairly unpleasant things at the front and centre of this discussion.
Grant, and then Peter.
To support Alan's point actually around the sort of jobs and employment side of things, I think that's something that we really need to have a good think about, because I mean, it is likely that if we are seeing decreasing deer numbers in Scotland in significant places, you're going to see potentially decreasing amounts of funding coming in from that sector. But you've got the same amount of work, if not more, and in terms of some of our species like Sika, certainly a lot of work to be able to get any of those. And I think the question is, who pays for that? And who, is that borne by the private sector? Is that borne by the public sector? Where's the balance between the two? And what's the best way to pay for that? Is that on deer, or is that actually on employment? So there's a bigger question about the long term, where you put your money, that needs thinking through, that isn't necessarily legislation, but it's how you implement the legislation actually in terms of that bit going forward.
And the last word, Peter Clark.
Yeah, just 2 quick points on lowland deer management and incentives. DEFRA in England offer a sort of equivalent through the agri-environment scheme, or the equivalent of that in England, a scheme that farmers can apply to for chillers and larders. So that could be some potential options for the Scottish AICS scheme. And then on the female seasons, obviously that was evidence put to the Minister, and because our members particularly had serious concerns around that extension to the female season. So,
thank you. So, a minute over time, I think that could be viewed as a success given the number of witnesses we've got today. So, thank you very much for your valued contributions. That concludes our proceedings in public, and we will now move into private session, and I suspend the meeting for 5 minutes.